Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, January 14th, 2025. We have 12 bills on the docket, and we're going to start off with Senate Bill 185. Sponsor panel would like to come on up. Welcome.
Hi. All right. Good afternoon, Chair Smith, members of the committee. My name is Jennifer Alger, and I'm the Executive Director of the Maryland State Ethics Commission. Pleased to be joined today on this panel with State Court Administrator Judy Roop. Also, the Deputy State Court Administrator is here, Nancy Faulkner. This is departmental legislation requested by the State Ethics Commission. Our office consulted with the Administrative Office of the Court on this matter prior to submitting it, and we're very happy to have their support on the bill and have them be part of this panel. State officials of the judicial branch, which are judges, judicial officers, judicial appointees, file financial disclosure statements electronically through a system that is exclusively maintained and administered by the judiciary. Currently, the public ethics law requires that a copy of each of those financial disclosure statements filed by a state official of the judicial branch be transmitted to the State Ethics Commission by the judiciary. Legislation removes that requirement. The judiciary is in the best position to establish both procedures for public inspection of these financial disclosure statements and provide prompt notification to state officials and candidates of the judicial branch if their forms are reviewed. This legislation removes an administrative burden on both the judiciary and the State Ethics Commission related to these copies. Section 5-104 of the Public Ethics Law establishes that the judiciary administers and implements the conflict of interest, financial disclosure, and public record provisions as they apply to state officials of the judicial branch. This legislation amends 5-104 to include the administration of these provisions where applicable to candidates, judicial candidates. This legislation also replaces references to the Court of Appeals with the Supreme Court of Maryland due to recent changes of the State Appellate Court. The State Ethics Commission thanks the committee for its consideration of this departmental legislation and seeks a favorable report, and I'm happy to answer any questions.
Excellent. Thanks. We're going to take questions at the end of the panel, so I see Senator West is up next. But
good afternoon, Chair Smith, members of this committee. My name is Judy Roop, and I am the State Court Administrator for the Maryland Judiciary. On behalf of the Judiciary, I am testifying today in support of SB 185. This bill will help to streamline the process for managing financial disclosure statements within the judicial branch. Current law requires the judiciary to send copies of financial disclosure statements filed by judges, judicial appointees, and judicial candidates to the State Ethics Commission after they are filed with our Administrative Office of the Courts. This process is redundant because the judiciary already maintains permanent copies of financial disclosures for judges, judicial appointees, and judicial candidates, and makes those available for public inspection. Current law places an unnecessary administrative burden on the State Ethics Commission by requiring the Commission to duplicate the work already being done by the judiciary. SB 185 relieves the State Ethics Commission of this obligation and places it with the judiciary alone. The judiciary is well positioned to carry out this responsibility using existing resources, and I believe it will save the state both time and money. We are also grateful that this bill clarifies the authority of the Supreme Court or its designee to carry out this important work. We join with our colleagues on this panel and urge you to pass SB 185. Thank you, and I look forward to your questions.
excellent. Thank you very much. Question, Senator West.
Thank you, Mr. Chair. So the reports filed with the State Ethics Commission are public, and members of the public can access them and review them. And occasionally, I get a report from them that someone's asked and not only asked to, but actually accessed my report to take a look at my report. So I know that's the case. How about with the judiciary? Would I be able, if I wanted to gain access to the judiciary's website and to review a report filed by one of the judges?
What you could do is contact the administrative office of the courts, and we have provisions to provide public inspection of any of these financial disclosures as they relate to judges, judge designees, and anyone that's applying to be a judge. So, yes.
Okay, so it's not available online, but I could actually go physically to the, I guess, to the Judiciary Center over, I can't remember the name of the street. It's over in outside Annapolis.
Yeah.
And go in there and actually physically view the report.
Yeah, we're happy to share any of those because of the requirement to have public disclosure of the documents.
Thank you very much.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you all very much.
Thank you.
All right, with that, that'll conclude the hearing and the testimony for Senate Bill 185. We'll now move on to Senate Bill 187. Administrator Neiser.
Good afternoon, Chair Smith and distinguished committee members. It's a pleasure to once again be in front of JPR. For the record, my name is Chrissy Neiser, Motor Vehicle Administrator, and I'm here in support of Senate Bill 187. Senate Bill 187 requires the MBA to disqualify a commercial driver's license or instructional permit holder for operating or attempting to operate a non-commercial motor vehicle with a blood alcohol concentration of 0.08 or greater. The driver will be disqualified from driving a commercial motor vehicle for 1 year for the first offense and life for the second offense. MDOT supports Senate Bill 187 as it will bring Maryland into compliance with the federal motor carrier safety regulations, which require commercial driver disqualification in these circumstances. A recent annual performance review contained a finding that MBA's CDL program does not properly impose those federal disqualification sanctions to drivers who have that administrative per se level with having a commercial instructional permit or driver's license when they're operating that non-commercial motor vehicle. Federal regulation requires that disqualification actions be taken upon a conviction, and FMCSA considers our administrative per se a conviction. As you know, that is a unique construct of Maryland law that does not exist in every state. However, the MBA is not currently able to impose a disqualification after an administrative per se hearing for test failures in a non-commercial motor vehicle. These are not considered convictions and may result in lesser charges of driving impaired, which is not a disqualifiable offense. With this change, the MBA will be able to take action against all CDL drivers who violate our impairment laws at the administrative per se hearing, which means they'll be disqualified more quickly. For some offenders, it actually means that they'll serve a potential administrative per se suspension concurrently with a disqualification action, as opposed to what happens today, where they endure that suspension period and then have to also take the consequences from the administrative per se hearing. So for those reasons, we respectfully ask the committee for a favorable report of Senate Bill 187 to bring us in compliance with the federal law.
Excellent. Thank you very much, Administrator Neiser. Questions from the committee? You see Senator Folden is up.
Thank you, Mr. Chairman. Good afternoon.
Good afternoon.
Thank you for bringing the bill forward. I'm just curious why we don't include, or we're not including, any like marijuana or drugs included, drug offenses for this.
So this mirrors what the federal law requires. We're not adding anything additional to it. This just brings us into compliance with what the federal guidelines are. On the commercial driver's license space, that's generally what we do. In fact, we have a section in statute that points to the federal regulations, but there are other places where we have unique requirements. This is one of them where we're just trying to bring that in.
Yeah, I understand that, but we just passed the legalization. You know, before it was not legal. Now we legalized the recreational use of marijuana, and there's nothing in here about if someone is stopped for driving while under the influence of narcotic. And I'm just curious why we didn't. I understand you're saying that you want to just come into compliance But why aren't we looking to, if we're doing this for compliance and safety, why wouldn't we include that?
So when it comes to commercial drivers, the federal guidelines really take precedent. Because the idea is that regardless of whether you're a Maryland CDL holder or you're a Delaware CDL holder, you should be held to the same standards. So because the federal government has a different view of marijuana and cannabis, that's not something they've adopted. If the federal government adopted it, then all the states would adopt it. CDL programs maintain that consistency to allow operators to drive among states and to be able to, complete deliveries interstate.
But don't we have the authority to make ours more restrictive than the federal guidelines? I mean, that is kind of the role of individual state government to be able to do
So I
that.
guess technically we can make ours more restricted. That's not what this bill is attempting to do. What this bill is attempting to do is to bring us in compliance with the federal program. I don't know. Bill Dacey's our.
So this is about compliance and not,
This is about
not
compliance,
safety
exactly.
for everybody because of the new laws.
Well,
that
certainly it is
passed.
a critical requirement, and
It
it's
is.
also one that is important. I don't want to downplay the action of disqualification, but this is a compliance bill. Yes, sir. Did you want to add anything?
I just think it's important that we include the idea that any narcotic, legal or not, would be included in that for a disqualifying measure by the
This is Phil Dacey,
MBA.
our Director of Policy and Innovation at MBA. He also manages the CDL program.
Hi, Senator. Yeah.
How are you?
So, already under federal law and state law, if you're impaired under 2192C or D, we do take disqualification action. So, but it's just at a different level. It's at the conviction level. So if you're convicted of operating while impaired by drugs under the 2192C or D, then we do take that same disqualification
Okay,
action.
so we have something on there. All right,
yeah.
very good, thank you.
No, I understanding like, Schedule 1 substance, if you have a dirty urinalysis, you have a CDL, that precludes you from having that CDL, obviously, and the enforcement, going to your point though, to how you test for this stuff, in this, so the language says the individual while holding a commercial instructional permit or commercial driver's license drives or attempts to drive any motor vehicle while the alcohol concentration of the person's blood or breath is 0.08 or greater. How are you testing for and or confirming that? Is it after someone gets pulled over and then obviously they have to, it's not the field that's admissible in court, so you got to go down to the station. So how are you confirming that? Because it's not, just for the record, because it's not explicitly clear in the language of the bill.
In terms of testing for drugs, how that is performed? Alcohol, okay. So alcohol tests, the initial test often happens roadside, but that can be confirmed, as you said, at the station. So it just depends on the circumstance. And so are you referring to the attempted to drive piece of the language? Is that what you're concerned about?
Well, so the road, because it was funny, we were talking about this last night. So, the roadside test is not admissible. It's the test that happens down at the station. And so which one, just for the record, for the legislative record in history, because it's not explicitly clear, which one are you using?
To your point, yes.
So it's the intoximeter test. So my understanding would be then, because of how this is crafted, that if they just refuse the test, they don't have.
Yeah, refusals all written.
Sorry.
Refusals already trigger the disqualification, so.
Okay.
Yeah.
All right, thank you.
Yeah, it really is this one very limited area where we just are trying to conform.
Further questions from the committee? All right. Excellent. Thank you very much. Thank you both. With that, that'll conclude the testimony in the hearing for Senate Bill 187. We'll now move on to Senate Bill 207. You're back.
I am back.
Welcome back.
Did not take long, did it? Again, for the record, my name is Chrissy Nizer, Administrator of the Maryland Motor Vehicle Administration, here to testify in support of Senate Bill 207. Each year, the committee has taken action to protect Marylanders from roadway fatalities and vehicle crashes. I appreciate your leadership in this area. And as you know, I use the word crash intentionally because the term is often used interchangeably with accidents. It's not a word that we use, though, because we often say crashes are no accident. Every year, the data shows us the same familiar factors that are causes to roadway fatalities. That's excessive speed, distracted driving, failure to wear that seatbelt, aggressive driving, and unfortunately, as we just discussed, impairment by alcohol and drugs. We know that drivers do not accidentally speed when they're going 20 to 30 miles an hour over the posted speed limit. They don't accidentally text and drive. That is a deliberate action, or consume alcohol before getting behind the wheel. These are all choices and bad decisions that drivers make that way too often lead to deaths on our roadway. On average, about 190 fatalities on our roadways due to an alcohol-impaired driver each year. Senate Bill 207 would revoke the driver's license from an individual convicted or granted probation before judgment from driving under the influence of alcohol or drugs for a period of 5 years if that crash contributes to the death or life-threatening injury of another person. Medical literature reports that individuals that have been sober for 2 years might have a relapse rate of 40%, but that relapse rate drops to 7% for individuals who've been sober for 5 years. Under current law, there's absolutely no distinction. So if you get a series of points on your license that lead to your license being revoked over a period of years, you're treated the exact same way as somebody who has killed somebody behind the wheel from a revocation perspective. There's no distinction in period of time when the consideration can be taken. Under Senate Bill 207, the same penalty would apply to drivers that fail to remain at the scene of a crash that results in the death or bodily injury of another person. On average, there are over 27,000 hit-and-run crashes each year in Maryland. While the vast majority of these crashes only involve property damage, there were 255 crashes involving a hit-and-run driver, which contributed to 258 fatalities over the last 5 years. After the period of time, the reinstatement process for a driver's license would remain exactly the same as it is today. By establishing more severe consequences for the most serious or reckless driving behavior, Senate Bill 207 will improve safety for all roadway users. I can tell you that I actually personally review the case of every individual applying to be reinstated after they've killed somebody. There are many requirements they have to complete, often in probation and other things from a legal perspective. This gives consistency and a sense of certainty to them as well, knowing there's a 5-year period to apply for that reinstatement process. For those reasons, I would respectfully request a favorable report and be happy to answer any questions.
Senator West.
Thank you, Mr. Chair. I note that in the bill, it takes the existing language that shall revoke the license of any person who has been convicted and adds to that or granted probation before judgment. Probation before judgment is generally a decision by the judge who's heard the testimony about the particular circumstances of the event and has made a considered decision to grant PBJ rather than convict. So doesn't your bill, at least to an extent, invade the power of the judge to grant probation? Because it's not just probation. It's probation plus losing your driver's privileges for 5 years. And if that's the case, why do you think it's important that we supplant the judge in these cases without regard to the facts of any particular case just across the board?
Certainly not our intent to supplant the judge's ability to grant probation before judgment in the circumstances that they seem appropriate. What we're trying to do is establish appropriate levels for reinstatement when it comes to revocation of the license. When the license is revoked, our ability is to be able to take action to restore that license, to put requirements on, and to make appropriate decisions. And so that really is the intent of this. Not to impede a judge's ability to grant probation before. Well,
as I read the language of the bill,
because the person would still, and I'm sorry, Senator, the person would be going through that process today. If their license was revoked, they're still going to go through that the reinstatement process today. What we're saying now is we want to establish that consistent period of time.
But as I read the language of the bill, it doesn't just discuss reinstatement. The beginning of the bill changes the revocation requirement. Right now, the administration is required to revoke the license of a person who's been convicted, period.
We can take a look at the language and just make sure there's nothing that needs to be addressed. As you change the bill, it's not only a person who's been convicted, but a person who has received a PBJ by a judge. So you really are, currently, if there's a PBJ by a judge, the person's license doesn't get revoked. It's genuinely a PBJ, as we've always understood a PBJ, which is you're on probation for a period of time, and if you err, you can come right back and you can get the original penalty
that you might have been subjected to. So in this case, what you're saying is, we don't care, Judge, what you've done with the probation before judgment. We're still going to take the person's license away. And I just wondered what the thinking was when you decided to ask us to make that change.
Phil Dacey, for the record, Director of Policy at MVA. And it's just something this committee has over the years made probation before judgment a revocable and suspendable offense, for 21902A. So if you get a PBJ for 21902A or B right now, you are going to also go through the same, like you were convicted. So because if you're drunk driving at those levels, at the 21902A or B levels, and you get a PBJ, we will take action based on.
Well, then if the law already provides this, why are we being redundant?
The process that we're changing on our law is what we're doing with the people who are revoked. So I think that's what Mr. Dacey is saying. We already would have revoked them. This is establishing what actions we take once they're revoked. So we're making sure we get the right category of people that we want to address from a highway safety standpoint to ensure that they've had time to be able to modify behavior. And the 5 years, I will say, is consistent with other surrounding states have done. We didn't, pull that out without doing some research. So there are requirements in many other states that people who are revoked under these set of circumstances wait at least a 5-year period before their license is reinstated.
Okay, so just to be clear, you're not trying to change the existing law. You're reinforcing what the law already provides with this language?
And providing consistency relative to the reinstatement time frame.
All right, thank you.
Senator Love.
That's right.
Thank you. Just getting used to the microphone here. Thank you, Mr. Chair. Good afternoon, Administrator. So good to see you. You just touched on what my question is. What do the surrounding states or the Eastern Seaboard states do? It sounds like this is consistent with what they do.
And we'll be happy to give the committee that information.
That would be helpful. Thank you.
Certainly.
Thank you, Mr. Chair.
Thank you, Senator Love. Further questions from the committee? All right, we'll probably follow up with this because I wonder, just for the, is that the current process for the suspension, is that for, you cited the code, and I forget the section of the code that you cited, but is that for a certain level? Is that for a certain blood alcohol level? That,
Yeah.
it's the super drunks, right?
Yeah, the 21902A
Got it.
and
Okay.
B, yeah, the .08 and the.
Got it, so now this is going to be inclusive of all.
Yeah,
Right.
so right now, we do take action on both those categories. It's just this sets it for 5 years. They can't be,
Understood.
if you killed or
Got it.
seriously injured.
Yeah, what's happening to their license is not changed. Maybe that's a clearer way to say
There
it.
you
It's
go.
what happens after the license gets taken away when they want to get their license back. That's the only part of the process that we're proposing to change in this
Understood.
legislation.
All right, thank you.
Thank you.
All right, thank you all very much. With that, that'll conclude the testimony for, and the hearing for Senate Bill 207. We'll now move on to Senate Bill 202.
Good afternoon, Chair Smith, Vice Chair Waldstreicher is not here, and members of the committee. I'm Catherine Kelly. I'm the Director of the Maryland State Police Government Affairs Unit. With me is Daniel Katz, the Director of the MSP Forensic Sciences Division. It's a pleasure to be here today to testify before you in support of our departmental Senate Bill 202. The bill clarifies accountability for the collection of DNA database samples, imposes a monetary penalty for qualifying individuals who refuse to provide a sample, requires refusals be referred to the state's attorney's office, repeals language that uses the term arraignment and replaces it with appropriate language in accordance with the Maryland rules, and establishes an expungement process for samples that not tested due to the arraignment language. The bill does not introduce any new mandate for DNA sampling. Senate Bill 202 is identical to House Bill 249 that passed the House last session. The language in the statute as it exists today has caused a cache of limbo cases. Since 2009, the samples in that category total 16,279 to date. Last year, the total was only 13,641. Director Katz will cover more about this in his remarks. Of note, the language used in the bill to replace arraignment, the arraignment language in current law, was developed in concert with the courts and the Attorney General's office to ensure the legislation does not require additional court hearings. Thank you for your consideration of this bill. We respectfully ask the committee give Senate Bill 202 a favorable report. Will be followed by Mr. Katz.
Good afternoon, Chair Smith and members of the committee. My name is Dan Katz. I'm the director of the Maryland State Police Forensic Sciences Division, and I'm here today in strong support of Senate Bill 202, which will significantly strengthen the efficiency and effectiveness of one of Maryland's strongest crime-fighting tools, the Maryland State DNA Database. Since the DNA database was established over 30 years ago in 1994, we have issued a staggering total of 12,412 DNA database hits to criminal investigators. SB 202 focuses on fixing 3 known problem areas within the DNA database statute. First, this bill will ensure that DNA is collected from all convicted offenders, arrestees, and registered sex offenders who are required to provide DNA. SB 202 clarifies who is responsible for providing DNA samples, who is responsible for performing the DNA collections of those samples, when collections are to occur, and how to handle situations in which the individuals refuse to have their DNA collected. Second, this bill eliminates an unintended consequence of the original arrestee legislation that has resulted in an ever-growing population of DNA database samples collected from arrestees that can neither be tested or expunged. The fundamental issue of there not being a clear and reliable trigger for the analysis of arrestee samples is addressed in SB 202 by removing the meaningless term arraignment and replacing it with language that instead describes actual mechanisms used within the Maryland criminal justice system to establish probable cause upon an individual being arrested. Third, this bill decides what to do with the existing population of DNA samples collected from arrestees that can neither be tested or expunged. In an effort to protect the rights of arrestees whose DNA database samples have sat in limbo since being collected, SB 202 opts to expunge all the samples that remain unresolved due to the previously mentioned loophole. For these reasons, the Department of State Police urges the committee to give Senate Bill 202 a favorable report. Thank you. Happy to take any questions.
Thank you very much, Mr. Katz. Senator West.
Thank you, Mr. Chair. I see the Office of Public Defender is opposing this bill and gives some reasons. And because we take you first and then we take them and you won't have an opportunity to respond to them, let me read you just a portion of what the Public Defender has to say and ask you to respond to it now.
Yes.
It says, under the proposed changes, it appears that the DNA could be tested as early as when a commissioner makes a probable cause determination and before the first scheduled arraignment date. Testing the DNA sample before the first scheduled arraignment date would undermine due process, as a person merely needs to be charged with such a crime and survive a minimal probable cause determination before the DNA sample is tested. Finally, they say, requiring an actual arraignment date on a qualifying offense makes the consequential step of testing the DNA of a legally innocent person more thoughtful and deliberate, as it should be. Testing a DNA sample is an irreversible invasion of an individual's privacy, et cetera. You see where they're coming. So what is your response to that argument?
Well, the issue is that they use the term arraignment, and arraignment is not a term that actually exists in Maryland. So we have been working for the past 15 years trying to deal with that. And this bill proposes actual points in the process where we establish triggers to cover that, to cover probable cause. So they are all legitimate triggers in the system that we worked with the legal system to establish, and that's the bottom line. So, is there anything?
Well, if I could follow up for a second, I think the Office of Public Defender's view is that taking a DNA sample of someone, which is I understand, pretty easy to do. I've watched enough police procedurals. You can take it off a glass of water, right? And then testing the sample. That's a real invasion of consequential invasion of privacy, and there would have to be some sort of a probable cause determination before you would do that. And the mere fact that someone has been arrested is not a sufficient probable cause determination. Do you agree with that as a philosophy, or is that something you disagree with?
Well, it's not accurate. So there is a determination of probable cause in those four methods that were described in the legislation. So it is being established. And it should also be pointed out that there's when this legislation was enacted, there were two triggers. And there's a trigger to ensure that testing occurs after the probable cause has been found. And then there's the automatic expungement trigger to ensure that if through the process the person is found not guilty, that those automatically be expunged. So those triggers still exist. They both function as was intended. It's just that by having those two triggers and the fact that the term arraignment doesn't exist in Maryland, it has caused this loophole. And we're trying to resolve that without without removing the concept that people are tested after probable cause has been established.
Okay, thank you.
Probable cause determined by whom? Is it a commissioner or is it a judge? And then when you, by expungement, do you mean like you remove them from the database? Like
Yes.
the DNA is gone?
Yes, both the records and the DNA sample are removed during an
Who's making that probable cause determination?
The commissioner, the district court commissioner, correct? Is that? Yeah.
Do district court
That
commissioners?
is an officer of the courts.
No, I
and-
understand. I respect that.
Yep.
But they don't have to be lawyers, and they're not judges. Okay. Senator Sinner.
Thank you. Good afternoon, Mr. Katz.
Good afternoon.
Question, one of the other pieces that the Office of Public Defender points out is that Senate Bill 202 also creates an additional crime for refusal to provide a DNA sample. I'm curious, are you aware of any data on how often people are refusing to do so and what kind of problems that may cause?
Yes, so it is something that has grown in commonality over the past several years. We get individuals who simply refuse, and because of the use of force topic that has, been in a subject of late, there is no forcing people to take their DNA. So individuals have learned that they can say no and then not get their DNA collected, and then they tell other people, and it sort of spreads. So there are people who should be in the DNA database but currently are not because they are refusing to provide it without any repercussions.
So the process goes on, this person goes to trial. If they're found guilty, I'm assuming at that point they would then be obligated, and there's a different force could be used, I guess.
Well, actually, I mean, it applies to both individuals arrested and convicted offenders. So they could be a convicted offender, be housed in corrections, and they go to take their sample and they refuse, and no one's forcing that collection.
And the reason I was trying to make that distinction, you had said earlier that there's an automatic expungement triggers. So I'm assuming that would be triggered if they're not found guilty.
That is correct.
And then the DNA would be.
So it's important to realize that there's two different categories of samples. There's samples that are collected from all felons once they're convicted, and then there's the arrestees, which are collected from individuals arrested and charged for crimes of violence and burglary. So those are two distinct areas.
And for those arrestees, if they're found not guilty.
Yes.
Again, it goes out the system.
That is correct.
Okay. Thank you.
Yes, sir.
Sorry to follow up, but so when someone's first brought in, has been arrested and processed, they're fingerprinted, correct?
They are.
So the fingerprints go into the system,
They do.
but you don't take DNA at that point, you just take the fingerprints. But the fingerprints are in the system and stay in the system, I guess, forever, right? Because they get uploaded to the FBI, and the FBI has them in the system,
Yes.
correct?
Yes.
And my understanding is the DNA is pretty simple. If I drink from a glass of water, I leave some saliva on the glass lip, that would be sufficient to get my DNA, right?
It would be, and I just want to clarify that for these arrestees that qualify, their sample is collected at the time of booking. It's
What, through a piece of spit or something?
It's on a swab, a cheek swab.
Okay, right, yeah.
But it's sent to the lab, and the lab holds it until that first trigger happens. So it's not, it exists, but it's not being tested until that first trigger happens. And then if that second trigger of expungement happens, it gets destroyed.
Okay. The fingerprint doesn't get destroyed, but
The fingerprint never
the
gets
DNA
destroyed.
would get destroyed.
Correct.
Okay, thanks.
Yes.
All right, further questions from the committee? All right, seeing none, thank you very much. Good to see you both.
Thank you.
Thanks. All right, with that, that'll end the hearing for Senate Bill 202. We'll now move on to Senate Bill 184. Hey, welcome back. But, the the secretary, former member of this committee for a long time, it'd be good to see her. Tell her we said hello, by the way.
Secretary Lee sends her regards. I'm sure she'd love to be here. Oh, thank you. I miss you all, too. You'd be surprised. Well, it's actually great. Let me just introduce myself for the record. Michael Laurie, Deputy Secretary of State. Such an honor to be back here. I spent a lot of time here. It's great to see District 16 represented here still, and my senator. Congratulations. We have a bill that passed this committee last year, and I think it's sponsor only. We do have our team if there are any questions, but I'm the only one signed up. I took that seriously. We have the bill. It's exactly the same as it was last year, except we requested an amendment last year, which didn't make it in, but I think we were promised it was going to be included. It just muddied the water a little bit on a clarification bill. The bill, as you have before you, is clean. We don't need an amendment, but there are two problems that it's trying to solve. Let me just iterate that, and if you have any questions, happy to answer them. The one problem is that we got audited a few years ago, and they thought that we had to send the collections to the Central Collections Unit, which would be a problem because then we lose the ability to negotiate with the charities. I'm sure you can imagine these charitable boards have a lot of turnover. Sometimes people make mistakes. We don't want to penalize these charities. They have good intent. What we want to do is bring them into conformity with the law. It has been our practice. It continues to be our practice. But if we get audited again, we want to make sure the law is crystal clear. And the second problem we have is that we have some charities which are on the books. They're listed as registered charities with us. It's the seal of approval in many ways, but a lot of them disappear, especially after COVID. There's probably a good 1,000 charities. We have over 19,000 that are registered with us. We could do some house cleaning and give them notice. And if they don't get back to us, we could take them off the roll so the public is aware they're not a registered charity. So that's all this bill does, those two provisions to solve those problems. And again, it passed this committee unanimously last year. Well, thank you. And I know we have our Director of Charitable Enforcement and our Assistant Attorney General. The charities obviously supplement a lot of the work that state government and the federal government does, and we just want to make sure the public is aware of the good charities that are registered with us and that we have a process in place to keep them in conformity with the law. So it's important that we have everything easy for them to be in conformity with that law so that the public is aware that they are indeed giving their hard-earned donations to the intended purpose.
All right. Seeing no questions from the committee, thank you very much.
Thank you.
Excellent.
Miss you guys.
Hey, likewise. Please give the secretary our regards. All right, that'll conclude the hearing for Senate Bill 180 and 184. We'll now move on to Senate Bill 197.
Thank you, Mr. Chairman, members of the committee. Thank you for the opportunity to testify in support of Senate Bill 197. For the record, my name is Jason Davidson, Director of Government and Legislative Affairs for the Department of Public Safety and Correctional Services. You have my written testimony, so I'll try and be brief. What you have before you is a very simple bill. It'll simply add the Director of Parole and Probation to the Correctional Training Commission. As you know, DPP is housed under the department and operates 37 different field offices across the state, and we supervise over 42,000 individuals in the community. The duties of DPP agents differ significantly from those of correctional officers, as you know by reading statute, Correctional Services Article 8-201. And the CTC, the Correctional Training Commission, sets the standards for correctional officers, parole and probation agents, and drunk driving monitors, and determines the training. So the director of DPP is responsible for nearly 1,000 positions that require annual certification and training through the commission. Additionally, the director is required to coordinate training needs with the commission to develop, secure, and make recommendations for evidence-based training per the statute. DPP has also developed a full 40-hour safety training curriculum together with the Correctional Training Commission. The new course for agents include classes on recognizing behavioral health conditions, defensive tactic trainings, use of force, those kinds of trainings, which are very valuable, and it's an upgrade over the 18-hour training that they once had. So given the fact that the needs of the Department of Corrections are represented on the commission, it only makes sense that parole and probation would be represented as well. This will ensure that the needs of DPP agents and supervisees are being better served by the training provided by the commission. The bill does not have a fiscal impact, and we respectfully request that you support Senate Bill 197, and I'm happy to take any questions.
Good afternoon, Mr. Davidson. ASME has submitted written testimony requesting that we move favorably with amendments. Their amendment is asking that a employee of parole and probation be, I guess, added to this list as well. As are you all opposed to that?
So if the, I haven't had a chance to read the amendment, sir, but if the amendment merely adds a parole and probation agent to the commission, we consider that a friendly amendment. It makes complete sense that since there is a correctional officer already on the commission, then a parole and probation agent as well should be on there as well.
And it reads, one parole and probation employee of the state recommended by the exclusive representative for parole and probation employee as specified and appointed by the governor.
That sounds like a friendly amendment to us, so we do not have any opposition.
Thank you very much.
Further questions from the committee? All right, seeing none, thank you very much. Good to see you. All right, with that, that'll end the hearing for Senate Bill 197. We'll now move on to Senate Bill 199.
Good afternoon, Chair Smith and members of the committee. My name is Bethany Young. I'm the Director of Policy for the Governor's Office of Crime Prevention and Policy, or GOCAP. I'm here to testify in support of Senate Bill 199. One of GOCAP's responsibilities is managing reimbursements to medical providers for the care that they provide to sexual assault survivors. Senate Bill 199 is a corrective bill that aligns current law to practice, the way that we actually process these reimbursements. Current law states that reimbursements are paid by the Criminal Injuries Compensation Board, CICB, which is a unit within our office, but it is not the unit that receives and processes and pays these reimbursements. In fact, it is the sexual assault reimbursement unit that receives the claims, and then GOCAP pays them. There are several reasons, including legal requirements, budgets, and processes that keep these processes distinct. Senate Bill 199 would not result in any changes to the way that medical providers are reimbursed or access reimbursement, and it would not make any changes to the process by which survivors can access important care. It just aligns the law with practice to hopefully clarify confusion for those who are looking to the law to understand how the process works. For this reason, GOCAP requests a favorable report on Senate Bill 199, and I'm happy to answer any questions.
Excellent. Thank you very much, Ms. Young. Questions from the committee? Senator West.
Thank you, Mr. Chair. Just tell your director, Ms. Lennig, that we miss seeing her. Oh,
It's right there.
she's here. Well, I think most committee members will remember very fondly Ms. Lennig, who has appeared before us many times. Thank you.
Yes, I'm very lucky to work with her.
Ms. Young, it was good to see you. Happy New Year. How's your kiddo doing?
What do you say?
How's your kiddo doing?
He's good. He's big.
I know. We're at the same stage of the kiddo stage, so yeah.
Yeah, lots of fun.
That's great. All right. Well, thank you very much. And with that, that'll conclude the testimony and the hearing for Senate Bill 199. We'll now move on to Senate Bill 201.
That is me again.
Welcome back.
Yes. For the record, Bethany Young here representing the Governor's Office of Crime Prevention and Policy to testify in support of Senate Bill 201 with amendments that GOCAP has submitted with our written testimony. GOCAP is responsible for several dozen legislative reports that cover our grant-making activities and the activities of our grant recipients. Our reports also collect and then report out information about various criminal justice processes. So Senate Bill 201 does two things related to our reporting requirements. One, it extends the deadline from September 1st to October 1st for several of our grant reports, allowing us a little bit more time to receive, review, and then report on the information we receive from our grantees. Senate Bill 201 also streamlines duplicative reports on youth involved in the criminal justice system. So starting with the deadlines, as I mentioned, we're responsible for managing many grants, and we report on those grants. Our grants operate on the fiscal year, and so we get quarterly reporting. For 4 of our grants, and those are the Body Armor Grant Fund, the Rape Kit Testing Grant Fund, the Protecting Against Hate Crimes Grant Fund, and grants we provide to child advocacy centers. The due date is about 3 to 4 weeks after the closeout of our final quarter, which often does not give us enough time to receive reports from our grantees and then review and synthesize that information to be included in a report. So it just gives us 30 extra days to do all of that, to make sure the reports are complete and well done. Senate Bill 201 also addresses various duplicative reporting requirements. Our amendments would leave intact 2 of those that are mentioned in the bill as currently drafted. So I'll start with the one that would remain. We currently are responsible for 2 different reports on youth charged as adults. One of the reports is a semi-annual report on youth charged as adults. The other requirement is an annual report on youth charged, convicted, and sentenced. So the latter report includes more information. Senate Bill 201 proposes eliminating the narrower report, and we would leave intact the more expansive annual report. As written, Senate Bill 201 also seeks to eliminate duplicative reporting on officer-involved deaths of civilians. We are under federal requirement to report on this information, and the Attorney General also under state law reports on that information. However, because of some concerns, which we agree with about kind of maintaining these things in state law, our amendment would leave that requirement, the state law requirement, intact. The final report that Senate Bill 201 as drafted addresses is around forensic genetic genealogical DNA analysis and searching. The report that we do on this, we request information from local law enforcement and state's attorneys. We've not gotten a lot of reports of this happening often. So the bill would space out the report to biannual. However, we've heard from our partners at MSP that there are some regulatory changes happening to how cases involving that kind of evidence are handled. And so rather than trying to do anything with this report, we're going to wait until those regulatory changes are completed, and then we will revisit the reporting requirement. GOCAP requests a favorable report on 201 with the submitted amendments. happy to answer any questions.
Thank you very much, Ms. Young. Senator Folden has a question.
Hi, good afternoon. Thanks for coming out. I'm just looking through the report, and it's very clear that you're delineating out officer-involved deaths versus a death in the line of duty. And you're saying that you're doing that because the Attorney General's office already captures that?
Right, so initially the bill as drafted would have eliminated the deaths involving law enforcement officers, deaths of a civilian.
Correct.
So the state law requires us to report on civilian deaths and also line of duty deaths,
Correct.
which we do. So the bill would have eliminated the civilian deaths piece because we report on that under federal requirement and the AG's office reports on it.
So I guess why are we taking it out where it's already in law if you're already required to do it?
So we're abandoning that change, so our amendments would leave the state requirement intact. So with the amendments, nothing would change. We would leave that in state law.
So it's going to stay in law that an officer-involved death of a civilian is still reported by GOCAP, right?
Yes, yes, with the amendments that we proposed.
Pardon?
With the amendments to the bill that we've proposed.
And I guess I just want to be clear, and you're taking out, so what's the major change that you're doing then? Because that's about half of it. Is the other thing about the juvenile recording stuff?
Right, so with the amendments, what remains from our proposal is changing the deadlines for those 4 grant reports and eliminating one of the juveniles charged as adults reports, because there are 2.
Okay. And what's the reason behind eliminating one of the 2 juvenile reports? Because in a time where juvenile crime has spiked, the frequency is kind of important for, in my opinion, for law enforcement to gauge and give a direction of and strategies for enforcement or deterrence.
Sure, so the reports are overlapping with one of them covering more information. So the report we're eliminating talks about charges. The report that would remain covers charges, case outcomes, and then where you are incarcerated. So the more expansive report would still be.
So but the more expansive one comes out when?
Once a year, so December 31st, I believe.
Correct, and when does the other one come out? It came out in the middle of the year, right?
It's semi-annual, twice a year, yes.
Correct, so that one does charges.
Yes.
It doesn't care about the disposition because we know that the courts, depending on, differing jurisdictions really adjudicate things a lot differently, especially when it comes to juvenile crime. So I'm trying to ask the wisdom of the department to get rid of something that is issued twice a year for law enforcement to be able to give accurate and proper responses in the protection of their community.
So, I mean, we see it as the information is still being provided, if not as frequently, but I hear your concern, and if that's an obstacle, then I think we would definitely be open to revisiting that.
But if you go away from that, then the bill does nothing between those
Well,
two.
it extends our deadlines, which is useful to the office in terms of having more time to complete those reports. So we believe that would still be valuable for our agency.
Okay, all right, thank you.
All right, further questions from the committee? All right, no worries. All right, thank you very much.
Thank you.
All right, with that, that'll end the hearing for Senate Bill 201. We'll now move on to Senate Bill 203. And we'll bring up the sponsor panel.
Good afternoon, Chair Smith and members of the committee. For the record, I'm Terry Seuss, Deputy Chief Operating Officer at the Maryland Department of Transportation, State Highway Administration, and I'm joined today by Dwayne Pierce with our Motor Carrier Division. It's a pleasure to be here with you to testify in support of Senate Bill 203. At SHA, we've been focused on delivering Governor Moore's promise of providing premier customer service, including more efficient government for all Marylanders. Senate Bill 203 would support SHA's mission to deliver on that promise by streamlining the hauling permit process, guidelines and rules for the agricultural community as it relates to the application and issuance of exceptional hauling permits for field-loaded farm products. In current Maryland law, hauling permits are specific to the farm-based products. For example, the permit to haul crops is different from the permit for milk, and hauling permits for milk are different from hauling permits for chickens. Under the current process, haulers must navigate a burdensome application, and SHA has identified multiple compliance issues, which then creates enforcement challenges. Senate Bill 203 would unify the 4 existing permits for various farm products and place them under one umbrella, making it less cumbersome and more equitable for farmers to obtain the needed permit. This would streamline the hauling permit process and create a more comprehensive permit for all farm products, which we expect will increase voluntary compliance. With increased compliance, SHA will then be able to collect more accurate data about what's being transported on Maryland highways and how it impacts our infrastructure by identifying routes that are used by haulers. SHA does expect to see an increase in permits with compliance, but there's no significant fiscal impact, nor are there any additional staffing requirements. For farm products, the unified guidelines represent a modest increase in gross vehicle weights allowed. This will reduce highway trips, fuel consumption, and emissions while posing no significant risks to the safety of the statewide infrastructure. In conclusion, Senate Bill 203 will improve customer service for those applying for hauling permits, improve overall compliance, and increase the accuracy for hauling data for our state. With that, I thank you for your time, and I would be happy to take any questions.
Just questions from the committee? All right. Thank you.
Thank you.
I can make a brief statement of support. I can make a brief statement of support.
Yeah, what was your name, sir?
I registered.
Yes.
My name is Robert Cooksey. I work for Maryland, Virginia Milk Producers. I have nothing written down. I'm in favor of this. It's a refreshing catch a breath of air to see regulations and rules streamlined that people can understand and be in compliance with. People want to comply with things, but they have to understand it. I'm full in support of this bill. We market the majority of the milk inside the state of Maryland for dairy farmers, and we supply the 2 largest fluid milk processing plants inside the state, and we have to constantly deal with both intrastate and interstate burdens. And the industry wants to be in compliance, but it has to be in compliance with rules that we can understand. So thank you very much.
No, thank you very much, Mr. Cosby. Sir, we have a question from Senator James.
Do I have to do anything else? I don't know this system. Okay, we're good. Oh, good afternoon, and thank you for coming down and supporting this bill. This is for you or the bill sponsors, because I am also delighted to see streamlining. I'm just curious, did you know the genesis of this bill? I mean, did the industry come to the state to ask for some look-see at streamlining and, lowering regulations, or was it the reverse, or do you even know? Just curious.
I'll speak to it. No,
Thank you.
I mean, I've been involved in transportation of agricultural companies in the state of Maryland for over 20 years. I'm a Maryland resident. I have been involved with the state over the years trying to look at a patchwork of hodgepodge of agricultural commodities that vary from state to state, and you have a lot of farmer interaction between state to state.
Right.
I quite frankly asked the state to look at this several years ago, and it sort of fell on deaf ears. It was proactive. I took a phone call from the Secretary of Agriculture saying, you need to look at this, and I was like, I am all for this. So I really give credit to SHA for taking a look at this and trying to make something better.
So if I were to characterize it, you had been interested, and I'm sure your fellow farmers were interested. Mm-hmm. It did not go anywhere several years ago, but then new administration comes in and you actually get a call on this very issue, following up on what you all were interested in to begin with.
That's exactly what happened to the T.
Very good. Thank you very much.
Yep.
Appreciate it.
Okay.
Thank you very much, Mr. Cooksey. And if the department would like to respond to the senator's question.
If you want to know what I was thinking, Mr. Chairman, I was trying to figure out whether the Moore administration was making concerted efforts across the board, and you all can only speak to agriculture, to try and streamline and make laws and regs work in the real world, when the rubber meets the road. So that was sort of my question to the department, but not for long, obviously. We can talk later about it.
Dwayne Pierce with the
Hi, Mr. Pierce.
SHA. Just to.
Oh, yeah, just that.
Just to clarify, this bill was passed numerous years ago. What the current bill that we're introducing today is a consolidation, essentially, of existing bills. It's also a streamlining of a lot of the burdensome administrative requirements that were associated with them that are really not associated with any other types of permits. So rather than essentially having set-asides or specifics for commodities, this will encompass all agricultural commodities that are field-loaded. And that would be the benefit of it. So.
But I guess my question is, you all can follow up. I don't want to make the hearing too long. I'm just trying to figure out how this germinated, in the department. I mean, who took the lead in the agricultural department and said, you know what, here's a good idea, let's do some streamlining? And you may not know right now.
Well, I guess I introduced the streamlining, but I was a part of the original one, and it was in need of some overhauling.
Thank you, Mr. Chairman.
Thank you.
It's always good when you can step up and say, that was my idea.
I know.
I'm
That's
the guy to
I
fix
like
that
it.
problem,
Yeah, I'm glad to hear it.
Yeah, right. All right. All right. So, thank you very much for that. That's great. Excellent. Mr. Miles can come on up, and then we'd like to hear from Grayson Middleton. Is Grayson Middleton still here?
Mr. Chairman, members of the committee, Bill Miles on behalf of Maryland's forest products industry. We're here in total support of this bill. It's been 2 years in the making. The rationale and reasoning for our support is evidenced in our written testimony that we sent in on time. And all I can tell you is this will give us in Maryland, the forest industry guys, a competitive advantage, a competitive level playing field with Pennsylvania, Delaware, and Virginia, which if you look at our testimony, can carry like 90,000 pounds on 5 axles, and we're at 87,000. So the last 2 years, we've worked with DOT, in particular, Mr. Dwayne Pierce, and we're very appreciative for the Moore administration for coming up with this bill. It'll be a great shot in the arm for forestry, which is indeed part of agriculture.
Excellent. Thank you very much. All right. Grayson Middleton. And then if you hold the testimony until I call the rest of the panel up, Lindsay Thompson, Rachel Jones. That's it. Come on up. All right, sir. Yes. Thank you.
Good afternoon, Chairman, members of the committee. My name is Grayson Middleton. I'm the Government Affairs Manager for Delmarva Chicken Association, and we represent the companies, growers, and allied businesses on Maryland's Eastern Shore. I won't belabor any of the points that have already been made by SHA, but I'd like to publicly thank them because I actually called Dwayne, to give you a little history, I actually called Dwayne sometime during the summer and told him that this is something that our haulers would really like to see, and he said, well, we're actually working on it. So that was fantastic. Just to really close out, I asked, we hire, our companies hire pretty much just one hauler across the board, and they're used pretty often. And I reached out to them and asked if they could provide us with a few data points that would demonstrate the impact that this would have both on the environment and on their day-to-day operations. And I'd really just like to read some of these figures for you because I think they speak for themselves. A reduction in the fleet of trucks by 2 or 8.3%, a reduction in annual miles by 169,000 or 9.1%, a reduction in annual loads by 2.4 thousand or 9.1%, a reduction in annual fuel gallons used by 33.1 thousand gallons or 9.1%, and an estimated annual transportation savings of 595,000 or 8.7%. Again, I think that those numbers speak for themselves, and I thank this committee very much and hope that you give it a favorable vote.
Oh, sure. Good afternoon, Mr. Chair, members of the committee. My name is Lindsay Thompson, here today on behalf of the Maryland Grain Producers Association in full support of this bill. We too would like to thank the agency for bringing this forward. I wanted to focus on one specific issue as it relates to grain production, and that is the field loaded aspect, to explain the need for this exceptional hauling permit. So the bill would harmonize the permits across all commodities and farm products, increase that to $88,000 for 5 axles and $90,000 for 6 axles. $95,000 for 6 axles, I apologize. And the reason that that's important for field loaded grain is our grain farmers are loading trucks in fields in remote locations all throughout the state and do not have the ability to actually weigh those trucks before they enter the roadway. And that oftentimes results in them getting pulled over and getting overweight, even if it's just marginally overweight tickets, which increases obviously their cost of operation. So this would provide a little bit of additional variance to address the issue of that field loaded and their inability to weigh the trucks before they enter the roadway. And with that, I would urge your favorable report. Thank you.
Yes. If the panelists could remain on the panel, just because I know that we usually just wait to the end of the testimony and then the senators will ask a question. But so is Mr. Middleton still here? Is he still here? Oh, come on up. I was going to ask you a question just to make sure your those numbers that you cited were in our bill file. So yeah, no worries.
Thank you. Good afternoon, Mr. Chair, members of the committee. I'm Rachel Jones, the Director of Government Relations for the Maryland Department of Agriculture. MDA was pleased to come alongside MDOT, SHA, and support this bill, which obviously is going to make things much easier for the agricultural industry across the state of Maryland. So as a part of the supply chain, the hauling piece is critical for Maryland farmers, and what we found is particularly the dairy industry. We know that this bill will directly impact over 129 haulers of dairy products that are predominantly located in Western Maryland, but we also recognize, as you've already heard from previous testimony, that it'll impact and benefit grain, forestry, poultry, and so just all manners of the agricultural industry. And you've also heard already how, in comparison to our neighboring states of Virginia, Delaware, and Pennsylvania, we already have a lower maximum limit of what can be hauled. And so this permit, in addition to streamlining things, also increases that maximum limit by 1,000 pounds. And so we think that's going to make a huge difference. One of the other things that MDA wants to highlight is Secretary Addix is a member of the Maryland Commission on Climate Change. And one of the things over the past year and a half that the commission has discussed is how the agriculture industry can work to be a partner in reducing greenhouse gas emissions. Fewer truckloads on the highway with this particular permit and the passage of this bill is going to make it possible for the agriculture industry to help make sure that we're doing our part to help reduce greenhouse gas emissions. And so with that, the Maryland Department of Agriculture requests a favorable report.
Thank you all. Very good panel. Really remarkably good bill here. I happen to have a farm. I might be one of the few legislators today, since Senator Middleton isn't here. There might be a few others. And primarily it's grain. We used to have cattle, horses, and things like that. To Ms. Thompson, I think, Lindsay Thompson was speaking to the grain production side of the bill. I had just a question that's a little bit of an aside. You indicated when you do field-loaded trucks, they can sometimes be even a little bit over, but it's quite something to be pulled over for this. And I've noticed in my driving around the state, there seem to be less weigh stations, but I thought maybe that was the improvement of technology. Maybe you don't have to go to particular stations. I wasn't sure what that was. So just briefly, could you explain to me when does a field-loaded truck get weighed, and why are there less weigh stations? It might be a good thing that there are less because there's some efficiency in technology, but not sure about that.
Sure. So I can't speak to why there may or may not be less weigh stations on the highway that you see publicly.
Yeah, I do.
But the juncture at which a field-loaded truck of grain is actually weighed is once they physically get to the feed mill or the grain elevator, right? So the truck pulls onto the scale, they measure it, they tear it for the weight of the vehicle, and that determines the number of bushels that you are being
So how does
compensated
this
for.
bill, specifically, since I want to report back to my own farmers, because I basically lease the land, how does this help them? Does it give them a window where they're not, I don't know, between the time of field loading to the, the mill? Are they given some latitude that didn't exist before? Is that correct?
So this bill streamlines the exceptional hauling permit to apply to all farm products, I think as defined in section 10 of the code, which includes grain.
I see.
And it increases the tolerance or the weight from 87 to 88,000 pounds for 5 axles, and then up to 95,000 for 6 axles.
Okay.
And so most of our trucks, like a tractor trailer load of grain, is likely going to be anywhere between 85,000 and 92, right?
All right.
And so it just gives them a little bit more leeway in completely filling that truck and not risking getting a ticket.
Thank you. I think you went over some of that, but I wasn't getting all the notes. Thank you very much. Thank you, Mr. Chairman.
Further questions from the committee? This may be a question for SJ. I just want to, if Wayne Norman were here, Senator Norman were here, he always would ask this question about the wear and tear. Now, you've tinkered around with the axle size and a little bit of the weight, so maybe it's this question for the department, but just for the voting session so that we have this answered before we vote it, can you talk to us about your analysis for wear and tear on bridges and roads?
Yes, sir. These weights have been validated and vetted by the Office of Structures at the State Highway Administration. But we have to keep in mind, too, that, remember, this is not essentially a new bill. These weights, previous to this, when it was introduced the first time and passed, that wear and tear issue was addressed throughout that period of time. So they have been, this is essentially the same weights that were afforded all this time to the milk industry as a set aside. Now it simply applies to all of the commodities in agriculture. And I would just suggest this, that the vast majority of specific commodities within agriculture are seasonal. So it's not 12 months a year that they're operating at these weights. It's only during the designated harvest seasons for the most part. So that's and that too lends itself to the wear and tear question. So, all right.
Well, since the chairman kind of tore the scab off on that, thank you. I appreciate that. I just wanted to put it out there. We mentioned earlier about being in compliance with federal regs. Is this bill in any way contrary to anything as far as federal motor vehicle or federal motor carrier safety standards? Is it contrary to that, or is it in compliance?
So allow me to address that. As far as the Federal Highway Administration goes, it is very specific what is the eligibility for a hauling permit for weight that is beyond that which is in the federal bridge formula, which all states must adopt and all states must comply with. So the difference being, and the key to that is, if it's an indivisible load, the federal government would suggest it's not eligible on the interstate system. Now, in 2015, the FAST Act designated milk as an indivisible load.
Right.
And as a result of that, we could issue a permit that was valid on the interstate system, like a bulldozer or a steel I-beam.
Right.
This is a divisible load, and as such will not be valid on the interstate system. And that is in keeping with the federal regulations and the size weight report that's submitted annually to FHWA by MDOT. So as a result of that, though, typically these field-loaded products are and between the field and the farm, there isn't a lot of interstate travel.
That's all I wanted to. That's all I was wanting to make. I appreciate it. Thank you, sir.
Thank you.
All right. Further questions from the committee? All right. Thank you all very much. Thanks. And I believe that was the last witness. So with that, that'll conclude the hearing for Senate Bill 203. We'll now move on to Senate Bill 195. Hold on, let me see here. everyone has signed up favorable with amendments. Mr. Secretary, come on up.
Happy New Year. Good afternoon, Chair and members of the committee. Mr. Chair, I'd like to request permission to invite my colleagues, Mr. Joe Jones, who is the leader of the Center for Urban Families and Essential Community Partner, as well as Dan Hatcher, Professor of Law at the University of Baltimore, to join us at the table, as well as Jonas Johnson, the Executive Director of the Child Support Administration. That works for you? Wonderful, thank you. I am Rafael Lopez, and I serve as the Secretary of the Department of Human Services. We respectfully urge your favorable report of SB 195, including our sponsor amendments. We are driven by 12 Moore Miller administration values and believe this bill exemplifies these values. SB 195 relies on research and data from successful states to make innovative, audacious, and long overdue changes to Maryland's child support program to strengthen families. And why? Because family matters. The purpose and function of child support programs have evolved since first authorized in 1975. It is time Maryland law evolves to bring our program into the 21st century. SB 195 will better align Maryland's child support program with the function and purpose of child support programs today, which is strengthening families by ensuring children have the support of their parents, because family matters. To ensure children have support from their parents, this legislation expands collection options and streamlines enforcement tools when a parent is unwilling to pay without punishing parents who want to pay but cannot afford to do so. Our work at DHS is meant to invest in and support families, not punish them when they're trying to make ends meet. Working with community partners like Mr. Jones, we want to increase the consistency of child support payments and offer resources to parents who are unable to make their child support payments. Our bill text was crafted in consultation and collaboration with partners in the advocacy community, and we are indebted to their wisdom and heart shared with us by the Center for Urban Families, as well as Professor Hatcher at the Baltimore School of Law. SB 195 is comprehensive, and its provisions are designed to work together. It represents the first major overhaul of the state child support system in decades by focusing on equity. We explore each component of the bill in depth in our written testimony, which I'll not repeat here, and we welcome your questions. Right now, we want to lift up the parts of the bill that implement our vision for Maryland's more equitable child support program. The bill would cap the maximum amount of a child support payment and arrearages at 25% of the parent's income. SB 195 would require a multifamily adjustment to the amount of child support order because a parent might be supporting more than one child. Our legislation would end transferring child support payments to foster care when a child must be or experience out-of-home care, a critical change that data clearly demonstrates safely reunifies families faster, because family matters. When child support orders are more equitable, parents can avoid arrearages and enforcement actions while improving payment consistency and reliability. If arrears do accrue, SB 195 would provide additional time to remove barriers to payment. SB 195 increases our engagement with parents who have a support order to remove barriers to payment by extending the time frame for filing a contempt motion from 3 years to 7 years. When implementing child support enforcement mechanisms, we believe it is critical to distinguish between parents who cannot pay child support and parents who are not willing to pay. Therefore, SB 195 would administratively exclude from the driver's license suspension program non-custodial parents whose income is equal to or less than 250% of the current federal poverty guidelines. Taken together, the provisions of SB 195 create a more equitable child support program for Marylanders and increase collections so children have the support of their parents because family matters. We appreciate the opportunity to give favorable testimony, urge a favorable report, and welcome your questions.
Thank you very much, Mr. Secretary. And then let's hear from the rest of your panel first. And I know we're all out of practice, second round of hearings. Let's wait when the witnesses, if you could just wait till I call you up, and then that way we have accountability of who's sitting here. I want to make sure the members have an opportunity to ask the department their set of questions, and then we'll roll on to advocates afterwards.
Absolutely.
So, Mr. Secretary, who would you like to speak next?
Mr. Jones, and then Mr. Hatcher.
Mr. Jones, could you please take the podium, if you're able to? Thank you.
Good afternoon, Mr. Chairman and members of the committee. My name is Joe Jones. I'm founder and CEO of the Baltimore-based Center for Urban Families. Our mission is to strengthen urban communities by helping fathers and families achieve stability and economic success. CFUF supports Governor Moore and Department of Human Services Senate Bill 195 with the inclusion of the sponsor amendments that they have introduced today. Specifically, the amendments, 1, establishes Maryland as a leader in evidence-based child support reform, better aligning practices with research on supporting child support well-being, although there will still be more work to do. It reduces wage garnishment to sustainable levels, helping parents stay in the formal employment. Current 65% garnishment on minimum wage jobs leaves only $4 an hour, pushing many into underground economy. Lower rates lead to more inconsistent payments. It updates child support calculation guidelines to account for all children supported by both parents, reflecting modern family structures. And lastly, stops requiring child support orders for foster care cases and allows existing orders to be halted, as these orders can delay family reunification by up to a year per $100 charged. Finally, we're encouraged by the department's willingness to work in collaboration with CFUF and other partners. As Governor Moore likes to say, those closest to the problems are closest to the solutions. When the government works with impacted individuals and the people and the organizations doing the on-the-ground work, legislation is more fair, more effective, and more impactful. I urge a favorable report with the amendments. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Daniel Hatcher. I'm a law professor at the University of Baltimore. Where one of the classes I teach is also a clinic where we represent low-income clients. In addition to my past background, where I was senior staff attorney at the Children's Defense Fund and also prior legal aid staff attorney and statewide unit. I've represented low-income individuals, both mothers, fathers, children, and all aspects of poverty law, and I strongly support this bill as amended. I thank the secretary and other members of the agency. I was impressed, very impressed by their willingness to work with all stakeholders in this matter to work towards needed improvements. I think, my key support on this bill falls into 3 major areas in those discussions as Joe Jones, and I've learned that as over the years. I think a good piece of the life advice is just agree with Joe Jones. I think he's absolutely excellent. So I think the reduction to a more realistic level of garnishment for low wage workers is enormously beneficial for everyone, right? Especially for custodial parents to make sure that the payments continue at a wage that doesn't stop the obligor from working and cause more people to work underground or to enter criminal activities, right? It's good for all of us because it allows those payments to go forward. It's good for the non-custodial parents because it allows them to actually get by, right, to be able to hopefully pay rent and continue to work and better themselves while they also support their families. It's great for employers, right, because now employers, this is a much more straightforward process, right, where they have this more manageable amount. It's more simple for them to know what the percentage is, right, so it's easier to implement, and they also know they're less likely to lose a worker, right, because of the garnishment. And I support the other provisions as well. I also just want to flag the foster care language in this bill as an incredibly important piece of the bill because it also, through the language, will encourage better support for children and parents who are pulled into the foster care system. So I thank you for the opportunity. I urge a favorable support as a member.
Ms. Johnson is here to support me in case there are questions I may not be able to answer. Good to see you, Senator. Happy New Year.
Just a question. Last year, Senator Watson and I put in a bill that passed out of our committee unanimously, and the language is not included in this at all. I want to know what you plan to do about fixing the licensing issue, and if we can sit down, Senator Watson, myself, your office, so we can include that language back in again?
We're happy to sit down with you and both senators. At the end of the day, as we research this, as you well know, Maryland has struggled to get anything done on child support for well over a decade. We want everyone to be able to chip in and figure out how to modernize a system that is not in the 21st century. So we look forward to partnering with you on that.
Thank you, my friend. Thank you, Mr. Chair.
Thank you, Mr. Chair. Good afternoon.
Good afternoon.
I'm looking at the first portion of the legislation, 5-111, proceeding to hold a person in contempt for default shall be commenced within, now it would be 7 years as opposed to 3 years. Can you talk to me why you're extending that?
Certainly. As our two previous speakers mentioned, and as we dove into what ends up happening with the rearages, we learned that the best practice is not to push people further away, but to engage them and to ask, why is it that people are having a hard time paying? We're making a very important distinction between a parent who is unable to pay versus someone who doesn't want to pay. We believe that the way in which the language in this bill is structuring is to engage. We want to be able to say, Mr. Jones, what's going on here? You are at risk of losing your driver's license. We don't want you to lose your driver's license. How might we work together to figure out how to bring you back in and support your child or children? So the framing of how the department is working at Child Support Administration is very different than the way in which it was founded decades ago. So extending that time allows a parent who is willing to pay the time to engage with us, to catch up, and to take advantage of a variety of supportive programs that are part of the rest of the department. For example, we fund a variety of services across the state to help a parent who is not employed or recently lost their job get employed, be able to get back on track. That takes time, as you well know. It might be engaging that particular parent in a very different way when they don't trust us because we're government. That's why the support and partnership of community partners matters immensely. And we've been prototyping this last year and a half or so, getting our people out of government buildings and into community, and it's working. It's not perfect, but one of the examples has been, for example, the Center for Urban Families. We've increased communication, increased access to programs, and we don't have to be the messenger. It might be more credible messengers than the government. Those are part of the package, Senator, that we're looking at in terms of giving people time and decency so they don't lose their license, they don't feel like we're punishing them, but we are holding each other accountable for investing in children and families.
A follow-up. Thank you, Mr. Chair. And so for those parents who aren't willing to pay the support, that those cases can be brought earlier. It's just you're extending it for those that you are working with, that you're engaging with, who want to pay but aren't.
Correct.
Is that correct?
Correct. Okay. And ultimately, the burden's on the department to make sure that we're clearly understanding who has an ability to pay but won't. And we believe that this bill doesn't detract from that. If someone simply doesn't want to pay and we have followed the law and given proper notice, we'll pursue that law. But we are trying to make sure to not punish the people who really do want to pay and just can't.
Got it. Thank you.
Certainly.
Thank you, Mr. Chair.
Thank you, Mr. Chair. Mr. Secretary, good to see you, sir.
Good to see you,
for bringing
sir.
in the bill. I've just got some questions about, and maybe you can expand into the impact on small business. I see that in the fiscal note it's saying minimal, but some of my questions have to do with, is there any new reporting or anything that's out of the norm when it comes to small business? And that's a third party who's involved in this.
Absolutely.
And so can you just explain a little bit more to me?
I'll build on after what Professor Hatch mentioned, which is that one of the things we've learned, not just here in Maryland, but nationally around best practices, is how do we engage businesses in general, but specifically small businesses, to make it easier to understand how government works. When we have different rules for different people, we place different burdens on those businesses. So we want to make sure we're as consistent as possible, and we think that this bill is going to streamline that engagement with small business. Once a law, should this bill become law, we would make sure that on the regulations and on the implementation of the practice side, we would keep it as streamlined as possible to make it easy for small businesses to engage us. That too is modernizing how we do our work. Oftentimes businesses don't want to contact us, and we are trying to be much more proactive. I'll give you an example of another set of work, we are deliberately and proactively working with Small Retailers Association of Maryland to understand, for example, how we can reduce benefit theft when people are using their EBT cards. That kind of proactive engagement is not something DHS has historically done. We want to learn from those kinds of engagement and do that right here, making sure that we are proactively messaging to small businesses about how to engage us on child support.
Follow up, if I may. So specifically about just reporting, do you feel that we're giving small business the ability to report within a timely fashion? I see that if they don't, the first infraction is like $20, but if they don't, it could go all the way up to $500. It seems reasonable, but I just don't know what compared to other states and your vast experience, which you've learned.
Happy to speak to that. So when I was first testifying, we talked about looking at more successful states that have begun to modernize their child support programs. That's the best practice we're looking at. There are significant pieces of writing around how we might change things. Maryland has our own way of doing things. We might take some of those examples and apply them here. We do believe, though, that the states that have been more successful in working with small businesses have been proactive in reaching out to them. That's not a muscle that our department and this state has regularly done. We have to prove folks wrong about our unwillingness to engage. That means proactive messaging, proactively reaching out to businesses, and then having them be credible messengers to their colleagues. So I know you own a small business. If you have good experience working with DHS, in this new work, you're more likely to tell your partners and your colleagues they're actually trying to change things. That is more effective to us than us just blast emailing or tweeting a particular issue. But all those tools I just mentioned, we've not historically used in trying to manage the department differently. We think all those tools are on the table at our disposal.
Excellent. Thank you, sir.
Chair. And Mr. Secretary, thank you for bringing this bill forward. I'm truly happy to see the multifamily piece added in, as that was one of the bills that I introduced last year.
Indeed.
So thank you guys for taking initiative to make this a part of the omnibus package. But I do have a couple of issues, and I want to just try to get some more understanding. The first part was already brought up by Senator Love. But when it comes down to initial orders, when they're first put in place for child support, they're backdated to typically when the filing took place. And when you're in jurisdictions like Prince George's County that has large backlogs of child support hearings, you can, if it's a high child support order that's set, could be $3,000, and you don't get into court for 10 months until you get a final child support order. You're $30,000 in arrears immediately. And so it looks as if you didn't pay child support or didn't want to pay child support, but in fact, it was just backdated. So how was that dealt with when it comes to the license suspension, when it comes to addressing, not putting these people on the bad person list? It's just how the system is set up that they're immediately in $30,000 arrears.
Certainly. I'm going to make one comment about that and then ask my colleague, Ms. Johnson, to also comment because she's been a stalwart leader on this work for a while. I will say that the biggest shift we're making, Senator, is moving from a historical culture in Maryland of punishment versus proactive engagement. That's an enormous shift. And as has been said many times, culture trumps strategy for breakfast, lunch, and dinner. So it'll take us some time to make the shift so that we are proactive in how we're reaching out to parents, particularly around the backdating. So I just want to say that in terms of a philosophical difference and shift. And then Ms. Johnson.
Thank you, Secretary. Ms. Johnson. Ms. Johnson. Good afternoon. Thank you for your question. That was an excellent question because we do get that all the time within the Child Support Administration. Because of the dockets within the courts, there is a delay, and then the orders are retroactive. What we do try to do, and what we are going to continue to try to do, is to work with the individuals. Because when they come to us with a brand-new court order, because of the delays getting into court, you're absolutely correct. They are already in an arrearage. But if there's something that we can do administratively so that we will not take those enforcement actions against them, we will do our best to try to do that. Because as soon as you put the arrears on the computer system, and of course, it may be reported to the credit bureau. But whether or not we suspend the driver's license, that is totally up to us, and we would not do that. We would try to work with the individual because we know that it's no fault of their own that they could not get into court in a timely manner. And it's retroactive to the date of filing most of the time.
Right, is there a system put in place? I know I've had some conversations with the office prior to you guys bringing the bill, but I know that was some of the conversation in terms of creating some policies that when initial orders are put in, you're not automatically sending over a license suspension.
Correct. And we
making that
continue to
mandatory
work through
across.
those policies to ensure that we do not do that.
Okay, and can I have one more follow-up question? And so the other piece that I have a question on is about the Maryland disabled veteran population, folks who are receiving disability benefits from the VA, and wondering how are those benefits impacted as I'm looking at the earnings. It's not listed there, and I just want to make sure we're not targeting some of our most vulnerable citizens across the state when we're looking at our disabled vets. And just taking their resources when this is all some of them have to live on.
Agreed. Senator Charles, that answer is simple. This bill is trying to do exactly the opposite, which is to not unfairly target anybody, use equity as a lens to ground the entire bill, and third, make sure we give people opportunities to engage with us.
But is that listed as, is that a part of the earnings?
It's not separately listed out.
So that is not, across the state of Maryland, disability benefits are not used as calculation for child support and then added into the arrears?
Yes, we can consider the SSDI, the Social Security Disability, because if the child is receiving the benefit on behalf of the disabled non-custodial parent or obligor, we can factor that into the calculation, and that individual will get credit towards the obligation.
Well, not SSI, but
no, SSDI, disability, yes.
Well, I'm talking about veterans disability, which is different from SSDI.
VA. I have to check that and get back to you on that one.
I know there's some federal talk about it not there's no provisions to be able to take that money from veterans.
And if that is the federal regulations, we are prohibited from doing that.
Okay.
Senator, we'll circle back with you on that because one of the things that this bill is also going to do is we compared what our partner office at the U.S. Department of Health and Human Services Administration for Children and Family, the guidance they provided to all states, who the quid pro quo is if we want federal money, we have to be up to speed with their current policies. We'll compare that. And if it's a federal requirement, that's a simple, we will not violate that, and we want to make sure we're in alignment with federal law. I will also say, since you asked the question for the record, that the posture we're taking both in this bill and moving forward in the Child Support Administration is to err towards not taking driver's license away. We'd rather have that be the norm than to automatically take licenses away, which has been a struggle for DHS in the past. And why that matters, as you can imagine, is when a driver's license is suspended, it has significant impacts on the customer. Turning that clock around is oftentimes much more difficult for CSA offices across the state of Maryland and for customers themselves. We believe this bill is going to help us shift that culture as well.
All right, thank you. And thank you guys also for constantly answering the question. I'm almost like the resident expert. I get a lot of calls in the barbershop from a lot of folks to what's going on. So thank you for always being there to answer the questions for a lot of my constituents.
It's a team effort, as you well know.
Thank you.
Thank you, Mr. Chairman. Thank you, Mr. Secretary. Thank you for the thoughtfulness of the bill. It's clear that a lot of work and a lot of expertise went into what you've crafted and put before us, and I just want to express my thanks for the thoughtfulness of the bill. I wanted to better explore extending the statute of limitation from 3 years to 7 years for the contempt actions. You mentioned a bunch of other enforcement mechanisms where you could encourage compliance, where you could incentivize compliance, support compliance. In my perspective, the difference between all those measures and contempt is the incarceration. Contempt is that kind of ultimate tool in the toolkit because you could incarcerate someone. To extend that lifetime, that window of being able to incarcerate from 3 years to 7 years, in my mind, just creates more opportunities for us to incarcerate someone. So I want to make sure I understand that these remedies are not exclusive. If we did maintain just a 3-year window on incarceration, would you still be able to pursue after that all those other remedies that would encourage, that would incentivize, that would get payments coming in through other means?
Thank you for the question, Senator Henson. I think the way we're trying to approach it, and certainly I invite other colleagues to comment, is that we want to not have to get to that point. So if we looked at the way in which child support, even its name as a child enforcement from the 70s, particularly through the 90s, it was about punishing mostly fathers. Now, women as well, mothers, but it was mostly fathers. And when we take a look and disaggregate the data of where that impact ultimately on whose shoulders that rested, it's mostly low-income men, and mostly low-income men of color. Now, that's not exclusive. So the question is, if you have a toolbox, what tool will you use to engage, again, mostly men and mostly fathers, but parents, to make sure that they don't ever get to that point where their license is not suspended, where they are not incarcerated. And what we think we're doing, as imperfectly as it is distinguishing between a person who can pay but doesn't want to, which goes to the enforcement tools as we need them, to a parent who is desperately trying to make ends meet and is just in so many arrearages, to the senator's point in Prince George's County, that it feels impossible to ever dig yourself out of what is poverty. We don't want to be in that space anymore. It's going to take some time to turn that around in terms of our policies, in terms of law, but more importantly, it's the regulations and how we enact what we have before you today. It's going to take a lot of shifts at all 24 departments of social services and their respective child support agencies, including in the advocacy community and the lawyers representing families, to imagine a different day in Maryland where enforcement isn't the only tool that we begin with, but in fact working proactively to empower parents to engage with their families. And it's the children and families mattering that is most important to us.
So I'm clear in your response. If there were still just a 3-year ticking clock on being able to incarcerate and those 3 years expired, could you still engage the obligors with all the other incentives and all the other opportunities to pay?
Absolutely.
Yes, absolutely. We would be able to do that. But also looking on the reverse side for the custodial parent and the child, because the statute of limitations after the child emancipates is 3 years. We're left to only the administrative remedies that are available to us. So extending the 7 year to the 7 year, that does give us another option to work with the individual by extending it to the 7 years versus the 3 years. Because if they don't hold a driver's license, and I'm not saying it in a punitive manner, but they don't have a driver's license, they don't have a bank account, they are not employed, or they just refuse to pay for those who could pay but are unwilling to pay, this just gives the administration another tool to be able to get those parents into court to determine whether or not they have the ability to pay versus those who are able to pay.
Thank you.
And are willing.
Mr. Chair, may I be permitted to follow up?
Yeah.
Thank you.
Sure.
You raised an interesting point, Mr. Secretary, and that's kind of some of the origins of child support enforcement and the ways that things haven't always been implemented with equity, and then even some of the ways that the unintended side effects have really borne out further exacerbated disparities. In the unfavorable testimony, I'd like to ask you to respond. It says, and I believe this is from Job Opportunities Task Force. I know we have multiple testimony from them, but a particular one that was marked as unfavorable says, per the Senate Bill 164 fiscal note from 2024, in 2003, the MVA suspended 20,512 licenses due to child support noncompliance. In the same fiscal note, OAH indicates that only 34 hearings were requested and were made in that same year. Further, the NAACP State Conference reported that Black parents comprised 71% of these suspensions from 2015 to 2020. So they've highlighted that of the suspensions, they provide the raw data and then say, according to the NAACP Maryland State Conference, that Black parents comprise 71% of these suspensions. The bill as written has a great deal of discretion in it. It gives the discretion to the secretary whether or not to pursue those payments when a child is receiving foster care maintenance, and in other areas it has a great deal of discretion. How would a person implementing the bill, who perhaps, I know that you will have an eye for equity and the way you implement this bill will be done with fidelity, but how do we safeguard and put guardrails up to make sure that with that additional discretion, we're not deepening some of these disparities that we've seen?
So there's lots of pieces to your question, and I want to make sure I'm addressing them. I do want to speak to something that has been a challenge for the state. That is one of the many gifts we inherited when we came into office. And one of them is two significant tech transitions, both for MVA as well as DHS. For DHS, the system of record for the state is CSMS, or the Child Support Management System. And there was a moment in time, for example, when MVA was transitioning to its new, more modern technology system, and there was a disconnect between MVA and the department. That is not a secret. And we have been moving with urgency to make sure that licenses that are suspended should be suspended. We, for example, have been really proactive in partnering with the MVA and our colleagues at the Department of Transportation to better understand even nomenclature, what they call X versus what we call Y, and why that matters, because what's at stake here is a suspension of a driver's license. And to your point on the statistics, oftentimes it is inequitably impacted in communities of color. So we're trying to be very deliberate about that, and we believe that it's also about the way in which the bill is implemented should it become law, which is providing really clear guidance, holding DHS accountable for consistency across the state. And one of the things I say is that we shouldn't have 25 ways of doing things in Maryland, 24 counties plus the central office. There should be one way of doing things in Maryland, particularly when it comes to the way in which we serve our customers. So it's a shift. And to your question, it's going to take some time to get there. It's acknowledging the challenges of the past, owning and taking action for the things that are in our direct control, and making sure we are erring towards not removing a license first versus assuming we're going to do that. If we follow the philosophy of this bill, it'll be the engagement that happens first, bringing them back into work with our local departments of social services and child support, and figuring out a solution. Our prediction, we hope that a year from now, should this happen, we're going to see even less suspensions. Why? Because we will have done our job even more effectively. Can I promise that right now? I cannot, much in the way in which we are disaggregating and untangling years of some of these actions. And on the issue of equity, it's pervasive in Maryland. There are challenges to the way in which this structure had been set up and ultimately codified, including practices that were inconsistent across the state. We want to bring this in line with consistency and respect and dignity for all of our customers.
I understand the goal. I am troubled by some of the discretion that exists in the bill, and making sure we have enough guardrails so that the sort of values that you bring to this would always be present in the way that we implement it, no matter who the executive was.
Certainly. And we're happy to work with you if there's particular language or you want to follow up with additional questions. We're happy to sit down with you and figure that out.
Thank you.
Certainly.
Thank you, Mr. Chairman.
That was good.
Thank you, Mr. Chair. I won't be nearly as good. So I applaud you for bringing this bill. I can recall a couple of years ago, I stood at a press conference with Attorney General Frosch, and we called attention to this problem with people losing their driver's license because they're in arrears on child support. And our question was, what is this helping in the state? So we were behind a bill some years ago. And the Attorney General Frosch hasn't been with us in a couple of years. So it's been quite a while ago. And I'm trying to search my memory to remember visually where we were when we had that press conference. I think it was over in the House of Delegates in one of the buildings, one of the rooms over there, remember me serves me correctly. So this has been around for a while. So it's a great bill. I do have some questions about it, starting with the effect on small business. So I'm looking on page 19 of the bill, which talks about the employer reporting twice a month. Why do we require employers to report this information so frequently? The governor, I know, has indicated that one way to get out of our problem that we're in financially in the state right now is to revitalize businesses, most of which in Maryland are small businesses. So we should be looking for ways of removing administrative burdens on small businesses rather than increasing them. So what is your thinking in terms of the frequency of the reporting that you're requiring?
I'll give you one perspective based on national best practice, and certainly others can comment. At the end of the day, most of us receive a paycheck every other week or twice a month, and there can be fluctuations in the income. And particularly when we're dealing with families who are trying to make their child support payments, we want to make sure that we are getting the most accurate information on income. When we do that, we reduce arrearages, and we don't get to a place where a customer's driver's license is at risk of being suspended. That's the logic behind it. Again, looking at states that have more effectively implemented modernization to the child support programs, these are the lessons we are learning. Is it the perfect prescription for Maryland? We don't know yet. We have not modernized this. And to your point of the press conference with the Attorney General, there have been many competing bills over at least over a decade in our research, and none of them have moved in Maryland. So I think the question for the General Assembly, for the department, for all the advocates in the community is to ask, do you want to go one more year and do nothing? Or do you want to actually make this the year where the Maryland General Assembly modernizes its child support program? That's the logic behind our thinking related to this. We do not intend to make it burdensome to small businesses. That goes back to the question earlier that Senator McKay asked. We think part of that is on our department to reimagine how we engage small businesses. As Ms. Johnson, I should say, she's our new executive director of the Child Support Administration, recently appointed, but has been with the department for many years. What I've learned from Jarnis, for example, is that we are doing things now that CSA has never done in reaching out to departments, to customers, to businesses. So I believe it's on us to be held more accountable to engage small businesses more directly and show them that with consistency and the ease of application of the law, we'll reduce their burden in terms of reporting, but also make sure it's easier to understand so not going back and forth. I cannot tell you the number of times small businesses have reached out to me via email or called me to complain about the burden of engaging with our child support administration. We are slowly but surely turning that around and being very proactive in responding, whether it's to businesses or customers who feel that we have been unclear in our messaging.
Well, that's why I'm a little concerned that the message that will, if this bill passes, that will go out to Maryland small businesses from the Chamber of Commerce or from whoever is that here's yet another burden the state's putting on you. You need to report twice a month, and if you don't report, you're going to get fined $20. And if they can find that you in some way collaborated or colluded with someone, it could be a $500 fine. That message to Maryland small businesses is not a positive one.
Understood.
Okay. Second question. I'm looking at the fiscal note, and we're hard up financially this year. This fiscal note shows an increase of $422,000. I assume the governor is approving the idea of spending an extra nearly $500,000 on this project in this next year?
I'm sorry. I thought you were asking me a question. Oh, so as you know, sir, any governor, any administration, we're at the place where this has all been approved by the governor's office. We were deliberate about making sure that we are thinking through the costs. I will say, as the Secretary of DHS, it has been a department that has struggled to calculate its fiscal notes over time, and I won't tolerate that. Why? Because it costs money to do these kinds of things. In order to modernize child support, we have to make sure that we are appropriately taking into account what it costs. There's also a federal drawdown. So it's not just a state general fund dollar, there's also federal money involved in this.
Okay, and then my last question relates to, it's on page 4 of your testimony. You say this bill would administratively exclude from the driver's license suspension program non-custodial parents whose income is equal to or less than 250% of the current federal poverty guidelines. Where is that in the bill or in amendments that you're proposing to the bill? I can't find it, but maybe I'm missing something. wasn't sure I got to page 12.
At this point in time, let me just read it. 1 second. This is why the team is here, to make sure I'm pulling the, 1 second. So, here it is. Amendment number 4. This is on page 18, Senator?
Oh, yeah.
Senator,
Yes,
this is on page 18, you mentioned?
Page 18
Okay, yeah.
of the
So
bill?
one of our sponsor amendments reads as follows. We would insert the numeral 3, for obligors whose individual income for the current year is not greater than 250% of the federal poverty guidelines, the maximum garnishment for the combined support order and arrearage shall be 25% of the obligor's disposable earnings unless the obligor was determined at the time of the most recent quarter to be voluntarily impoverished. And on page 18, that would strike lines 11 through 16 in its entirety.
Okay, and that would cover non-custodial parents?
Correct.
Okay, thank you. Let me go back and take a look at the fiscal note on page 12. Well, I'm looking at the fiscal note on page 12, which says the Department of DHS advises that it requires 29 new caseworkers to establish an obligor's actual income, and at an annual cost of approximately $2 million. Is that accurate?
My apologies, Senator. I was trying to look to the right.
Yeah, I'm sorry. It's on. Yeah, it's a very dense fiscal note. It's on page 12, and it's just down a little bit from the top, beginning of a paragraph. DHS advises that requires 29 new caseworkers to establish an obligor's actual income, et cetera, at an annual cost of approximately $2 million. So is that $2 million of additional spending to hire these 29 new caseworkers?
I'll have to get back to you on that, sir.
Okay, thank you.
Thank you, Mr. Chairman, and thank you, Mr. Secretary, for coming today. I really appreciate your bringing this bill, and I am ideologically and philosophically aligned with everything you're trying to do here. I guess I have a little skepticism about implementation, and that's what I want to ask you about. 2 years ago, we passed legislation for a different agency, with which I was also philosophically aligned, to have that agency have more responsibility over juveniles in our system. And even though we were all aligned philosophically, what happened was the agency, in fact, and we'll learn more about this tomorrow, was unprepared for the additional responsibility and the cultural change necessary within the agency. And outcomes didn't get better. Maybe they will over the long term. In certain circumstances, outcomes became worse because they received new responsibility and were unable to implement that responsibility. So when you say that you prefer engagement over enforcement, I do very much as well, and that's attractive to me. But I also prefer enforcement over nothing. Mm-hmm. And so I guess my concern is if we pass this bill, is your agency ready to and prepared to implement it with fidelity on day one, so that we don't have a gap between what our current regime is and what the regime that you have in this bill seeks to implement?
So, I believe in answering honestly. I won't be the secretary of this department forever. The team that's with me won't be the team forever. And the way I think about this is I'd rather take a swing every single day with this team and actually change things in Maryland than to accept the status quo. And this is not going to go into effect if it were to be passed until 2026. It would provide the department time to make the regulatory and policy practice changes needed to engage people across the department in all 24 jurisdictions. Why? To make sure that on day one, there's consistency in application of the law, so that you have both the engagement and, where necessary, the enforcement. But I'd rather swing at it every single day as a team than to assume nothing. And again, I can only speak from the facts that I know of Maryland. For years, I think it's 12, if not 13, there have been some bills to do something on child support. Many senators have mentioned that. Not a single one has moved, not one. So the question for all of us is that what y'all want? Then let's do nothing. If you want change, then we do something and we negotiate and we compromise to actually bring a new day in Maryland on modernizing child support to make sure in the 21st century, so that the codification withstands the turnover of secretaries and gubernatorial administrations to do what? To modernize them as they see fit. Elections matter, and a governor has the ability to appoint whatever secretary they want, and that secretary will come in and try to make their changes. I think that at this point in time, given the research we've done and the best practices we've seen, Maryland is behind the times here. I would like us to lead. I would like us to think about how we center equity, center engagement, and move Maryland's child support system to a different era. We believe this bill, by looking at many of your previous bills, does just that, however imperfectly it might be.
Well, one follow-up, Mr. Chairman, if that's okay. I agree with everything you're saying, and I appreciate that you brought up, the changes in administrations, which happen, and this is the third governor that I've served under. And so I guess if you created a hypothetical, if we were to change things as this bill lays out, but a new administration was not ideologically committed to what this bill does, would we unintentionally remove other tools that could be useful or are better than nothing? Does that make sense?
It does. I understand what you're saying.
If another administration came in and said, oh, we don't want this, but then we left them no other tools to utilize, we might be worse off.
That's a great point, but I will say this. Dealing in a world of hypotheticals, right? Which is that, what do we have today? What we have today is not good enough for Marylanders. Let's just say the issue of multifamily adjustment. If a parent has 3 children, for a court not to be able to take into account in its orders the impact of their own earnings on 3 children that may or may not be in the exact same family, how is that helping Marylanders? Our answer in this administration is it's not. It's bad practice, it's bad policy, and it fails to actually take into account best practice nationally. We could choose to do nothing there, or we could choose to do something. We're choosing to do something, number one. Number two, it is the right of a new administration, Republican or Democrat, whoever wins the governor's office, to come in and say, I don't agree with that policy, and guess what they have to do? Come before the General Assembly and pitch their case. We've come in, taken a look at child support in this state and said, we don't like what we see here. It's not working for Marylanders. And as Jonas knows, we have 1,000 complaints about how it's working right now, which is it's not as effectively as it should be. So again, to your point, we're trying to model moving with urgency to at least give it a shot and make a change, Senator. And we do believe that with these changes and with the time to amend our regulations, amend our policy and practice, we'll get to a better place for the customers in whose names we serve. To do nothing is not, in our case, is not going to work for us.
Thank you. Just a few questions. Your amendments, there are about 6 amendments that you all have. OPD has suggested 2 amendments. I think Maryland Legal Aid, seems like there are 3 suggestions that they have, and JOTF has 2. Are you privy at all to?
Yes, I will say that, as you well know, we get the access to these favorable or unfavorable testimony plus amendments pretty late in the game, much the way you do. I will say to you that with all of them, our team is already working on reviewing everything that we've laid eyes on. We're not prepared today to say yes or no to any of those suggestions. We are seriously taking into account any amendments, either from senators, members of the House, or advocacy organizations. But literally in the last 24 hours, we have not even conducted the full analysis. And we intend to be clear and to communicate with those advocates or those making amendments to say why we will or will not support those amendments.
Okay. Also, I think within the official system, there's just one organization that has requested an unfavorable. However, by email, I received another from Family Reunion, and they mentioned that they believe that the proposed changes would not align with the federal requirements.
So I can respond to that. As a former Fed, one of the problems that we have right now is Maryland is struggling to make sure that we are responsive to the federal government, and it's a quid pro quo. If Maryland wants the federal money, we have to be in compliance with current federal law and regulations. This bill does just that.
Very good. And the last thing, let me see. All right, this actually may not be a question for you, may be a question for council. I think the secretary had mentioned, well, our, Senator Henson had mentioned the possibility of administrations changing and agents or officers of DHS applying the law in different ways. So one way of kind of ensuring that that compliance is consistent across the board is, I guess, through regulations. You've kind of alluded to putting in the regulatory regime, but is it necessary for us to put within this law or this bill requirement to put in regs, or do we just rely on the department to do so? And that's for you, counsel.
Sorry, Senator, I was distracted on that. But
no worries.
Mr. Prada.
I think I would have to maybe take a look. There may already be requirements some requirements for the department to adopt regs, and this may kind of slot into that. I'd have to take a look at the exact statutory provisions to see that.
Thank you. Thank you.
Thank you, Mr. Chair. Thank you, Mr. Secretary, for being here today. So I just want to echo my concerns, much like my colleague, Senator Henson, brought up about the concern for the disparity in what appears to be enforcement amongst races and how this is applied. Because much like she pointed out to, without proper guardrails, and I don't see those fully here, it is left up to whoever the caseworker is to suspend the license or not suspend the license, or the different, opportunities. Right. So that's a concerning part of this for me. You brought up about us coming into the 21st century. I want you to tell me, because you mentioned that other states are doing, really, I guess, great things that we're not. Who are these states? And right. I'd love to know what states you're referencing. Sure.
So I don't have, we actually did research on the best practices. I can give you that list of states. I just don't have it in front of me. So I don't know any of them off the top of your head? I mean, this is what you testified on, that other states are doing this. So I would think you'd have some idea. Yeah, so California is one of them, for example. Okay, well, California's in a lot of debt. Understood. But hold one second. I want to give you, so hold one second. There were 12 states that we used to look at best practices: California, Colorado, Connecticut, Iowa, Maine, Massachusetts, Nebraska, New Hampshire, Ohio, Texas, Utah, and Virginia. And they all do this? Well, so I should say, or is that just what you looked at? We looked at best practices nationally, and those were the states that helped us better understand this. You're not going to find an exact, like, Texas has this bill and this is exactly how Maryland's doing it. It's trying to understand what's happening across the country. I also think, to your first question, I do want to say on the record, because we struggled with this last year, there is a perception that, and it was said on the record, that individuals have the discretion to suspend, for example, your license. That's actually not factually correct. And not you personally, but a caseworker can't say, I don't like Senator William, and so I'm going to suspend his license. Oh, there'd be a lot of people saying that. Well, but I think it's important to say on the record, there was mention last year of things that don't exist in Maryland, and I want to make sure that on the record we're saying we want to be fair, consistent, and equitable. And the guardrails actually do exist right now. We're trying to strengthen those guardrails so there's consistency across the entire state. When even a letter is issued to a Marylander that says you are at risk of losing your license, and making sure that the customer knows how to engage us so they don't lose their license. So
they're not engaging you personally, so who are they engaging?
So it could be at the local county.
Caseworkers.
Right, well,
And
correct.
then who makes the recommendation to take away their privilege?
Well, ultimately, it's coming from the Child Support Administration, from us to the MBA.
That's not what I asked. Who makes the recommendation to take away their license? The caseworker. Pardon?
They should not go outside of the policy.
Right, so I can repeat, this is something that you were there, weren't going to join me, but here's what I'm trying to say. So you're right, it is a caseworker. I can say that on the record.
And they make that recommendation to who?
This is important. A caseworker cannot randomly decide to remove a license. They have to follow the policy.
Oh, I'm familiar with what's supposed to happen.
Right.
What I'm saying is what in practical application is allowable or could happen, maybe without you realizing. So is it permissible then? You just said that what was said last year was wrong. So what you're saying is that a caseworker is not the one that sends off the recommendation to suspend the person's license. Is that correct?
Ultimately, a human being is going to...
Please don't play semantics. I'm asking you a very direct question.
Oh, I know, and I'm being very direct with you.
Senator,
and I'm saying that I'm telling you,
I got you.
a person...
Ultimately, a human being, no way, really?
One second. Just, okay, I see what's happening, and I have feelings on both sides. So he's asking a very specific question. So it is a caseworker, yes. Okay, within the guardrails of the existing policy. Okay, and then what happens next? Because he's asking. I know it. I just see what's happening. I just want to make sure that he's asking very finite, direct questions, and maybe it helps to just on point without the context, add the context after answering the question, and then I think it'll help ease the flow of the conversation.
Because who takes that recommendation? Does it go to different supervisors? Does it go somewhere else? How does it go? So who makes the recommendation is the caseworker, and then who's the one that submits it to the MVA?
Thank you for that question. It's sort of twofold a little bit, so I'll try to explain it a little bit.
Okay.
There's a compliance when a non-custodial parent reaches a certain compliance balance when they're out of arrearage, when they meet a certain arrearage amount.
Okay.
They have to be out, and our system is programmed to say this non-custodial parent meets the criteria by being out of compliance with the policies.
Okay.
Then the non-custodial parent receives notification that they are out of compliance and they had a certain amount of time to come talk to the local child support worker.
Okay.
Okay. They can contest it. There are many reasons for the protest as to why the license should not be suspended. If it meets the hardship criteria, the workers can exclude them, yes. The worker doesn't necessarily make the decision to personally send them to the Motor Vehicle Administration for suspension. If they do not come to see the child support worker based on the notification that they receive, then the system sends them to the motor vehicle as a referral. They also receive notification from the Motor Vehicle Administration that they have received a notification from the child support agency for the suspension. So I'm saying that to say that, yes, a caseworker makes the decision to exclude them, but if they don't come in and engage with the child support office regarding those matters, that would preclude them from being suspended. Yes, the system is going to automatically refer.
When you're saying the system, is it the computer system automatically refers,
system.
or so the only thing your advisors, your counselors, the only thing they can do is exclude them?
That's correct. That's why I said it's sort of twofold. So a worker doesn't decide to suspend an obligor's driver's license just because. It's an automated and it's programmed within the system to say that they are out of compliance with the policy.
I just want to be very clear. So what you're telling me is that there is no administrator, no one in your staff that makes the recommendation
To suspend?
To suspend?
Not if they meet the criteria. That information is not made by a worker to suspend. No, that is based on policy and the referral or the selection.
Okay, so I guess what I'm getting at is part of my concern there is that there, there's a lot of people who don't trust the government.
Yes.
I'm with the government. I'm here to help. You call me up as a child support group, probably not thinking you're trying to help me. Okay? By the numbers, if the data is accurate that the senator brought up at the 71%, do you understand that either maybe these people, because of their situations, are not getting the notifications and thereby being left out, and they're getting suspended without being, duly notified through what's available, whether it's because they moved or because of their housing situation or their lower income and are, migratory a lot to different places. So it seems by this practice that we're potentially singling out an economic group more so than even the racial guidelines.
Senator, actually, if you don't mind, I'm going to ask Mr. Jones to give an example of what we've tried to model with his organization on the ground this year. Many of the issues. No,
I don't need to. We don't need to have any more of the committee's time. I just want to know, like, you can get that to us in writing. We've spent a lot of time on this. I'm just pointing out another concern when you hear these things, and we're trying to do this, and then the other states, and you're saying that you looked at them.
Right.
I mean, there's not one. You're telling me that what you're telling us is that there's no one like solid thing in place, that you're trying to piecemeal from a lot of different formulas that are out there to make this our own, is what I'm hearing. And this has a cost of potentially $2.4 million. So I just am concerned about the money aspect, but I'm also concerned about the disparity in how it's enforced because of different socioeconomic factors.
Understood.
Okay.
I completely understand what you're saying, Senator, and much of what you've lifted up is part of what we're trying to solve. At the end of the day, you have a judgment call to make about whether or not we've hit the mark on this or not.
Yeah.
We also, if you have specific questions or amendments you'd like to make, we'll sit down with you and walk you through those. At the end of the day, though, it is my job on behalf of the department to try to look at what is working elsewhere across the country and try to bring to Maryland some way to modernize what we have. Because what we have right now is not working as effectively as it could and is not rooted, we believe, in the kind of equity that we think is more important for people who are struggling to make ends meet and are willing to but cannot pay.
I appreciate your time, Mr. Secretary.
Absolutely.
Thank you.
Thank you, Mr. Secretary. Ms. Johnson, or Johnson?
Johnson.
Thank you thank you for walking us through that. That was very, very helpful. Further questions from the committee? Okay, excellent. Thank you very much. Thank you all very much. Good to see you, Secretary. All right. With that, we'll move on to Mr. Woodward. Come on up. And that's it. That's it for the.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. I'm Mark Woodard on behalf of the Job Opportunities Task Force in support of Senate Bill 195 with two amendments. The one amendment is related to the language on the bottom of page 9 about the obligor's income is not greater than 250%, et cetera. The department wants to make this an additional factor for them to consider whether to suspend the obligor's driver's license. We believe, like this committee believed last year, you supported a bill from Senator Watson that exempted obligors who are earning 250% of poverty or below from having their driver's license suspended. We support that amendment. We support doing that again and to amend this particular part of the bill to make it clear that if you're earning 250% or less, which is $37,650, then you're not going to have your driver's license suspended. Clearly, there can still be enforcement actions, there can be wage garnishment, and so forth. And again, this committee passed that bill last year. We agree with your action from last year. The second amendment we're proposing is to speak to how the department can verify income. The comptroller's office can enter into a memorandum of understanding with the department to provide taxpayer information to them to ascertain who should get that exemption. The current law and practice seems to us to be counterproductive in that it takes away a person's driver's license and then they can't have a job or an income. For these reasons, we support the bill as amended. Thank you very much.
Thank you. Good afternoon. My name is Alice Mutter. I'm a supervising attorney with Maryland Legal Aid. Our family law attorneys represent both custodial and non-custodial parents in family law matters, and we specifically focus on low-income Marylanders. We urge a favorable with amendments report on SB 195. This bill does have positive changes, including the multifamily adjustment, which allows parents who have multiple children in their household to have that accounted for financially in their income calculations, and clarifying that support cases should only be filed against parents of children in foster care in very limited circumstances. However, this bill fails to address many of the systemic flaws with the agency's automatic driver's license suspension program. And to Senator Folson's concerns, Legal Aid has the exact same concerns as well, which is that this is an automated system. The MVA receives a list daily of hundreds of people who should have their driver's license suspended, and a human has not looked at that list. This bill purports to create an exemption for low-income Marylanders, but it does not. It does not stop suspensions from happening, and it doesn't take into any consideration the fact that there may be people on this list who have an exemption that is applicable to them, but they have not had an opportunity to assert it because they are notified on the back end. What good is another exemption on paper if the parents do not have an opportunity to raise these prior to a suspension? Fixing it on the back end is too late, and the harm has already been done. They already have a criminal citation for driving on a suspended license. They've lost their job or had their car impounded or missed an important event in their child's life. Legal aid clients with suspended licenses are disabled. They're seniors oftentimes on fixed incomes, or those who need their license for work. We have to help their licenses get reinstated, and they are at risk of suspension over and over again. Language such as that proposed last year by Senator Muse or Senator Watson's bill, we think would address this if it were incorporated here. I'm happy to take additional questions as well, although my time is up. Thank you.
Thank you very much, Ms. Mutter. So questions for Ms. Mutter or Mr. Woodward from the committee? All right, seeing none, thank you both very much. Thank you all. All right, that'll conclude the testimony for the favorable with amendments. We'll now move to the opposition panel, and if we could hear from Ashley Devon and Dawn Burton.
Good afternoon, committee and chair. Thank you all so much for hearing this issue. I'm here representing Out4 Justice, and Out4 Justice is a nonprofit organization led by individuals directly impacted by the legal system. We are here to oppose this legislation. We heard a lot of different things today. Most importantly, we heard equity, family matters, and cultural shift. We do believe that this secretary and this administration could be the ones that are able to get us to a cultural shift, but as this particular bill stands, it has not gone far enough. We've talked about the racial disparities. We've talked about the fact that driver's license suspensions for low-income individuals have not been included. However, the point that I want to focus on is that the department lifted up that the last year and a half that they've worked to pilot community efforts. And while they were working with the Center for Urban Families in Baltimore City, we had OFJ members in Baltimore County and Charles County who received 4 separate suspensions of their licenses, causing them to have to walk and commute back and forth to work. I want to lift that up because as we're talking about passing this sweeping bill, we have to talk about not just the racial equity issues, but also if I live in Frederick, Anne Arundel, Harford County, Garrett County, Allegheny, Washington County, Carroll County, or some parts of Prince George's County, I have absolutely no access to reliable public transportation. If my license is suspended, I cannot work. And we have far too many individuals that are facing this. We also don't have enough data and research to say who would be impacted by these particular changes, where do those individuals live, and what else can be done. There needs to be further conversations and amendments on this particular legislation, and also we need to begin to look at this from a way that will allow us to implement some legislation with fidelity, and that could be a study group or a work group. And for those reasons, I'm asking for unfavorable on this bill.
Good afternoon. My name is DeWine Burton. I am the Deputy Director of Out for Justice. As Ashley mentioned, we are an organization that's focused on policy reform, education, and advocacy, specifically for those who are directly impacted by the criminal legal system. I'm here as an advocate, but also as a mother and in the community, and understanding the intricacies of the collateral consequences the individuals, specifically those who are already marginalized, face when it comes to child support enforcement, and the inequities and disparities and how those are enforced. One of the things I wanted to mention are this introduction of the 1099 and garnishing of wages from independent contractors. And so particularly for folks who have a criminal record, it's already difficult for folks to secure employment, housing, and a bunch of other barriers. So some of the ways that they secure employment or compensation is through independent contracting, whether it's creating their own business for cleaning or other ways that they find ways to secure compensation to support themselves. And so what we're doing in this is introducing something that doesn't currently exist by garnishing wages from 1099 independent contractors, which again is also not equitable. We're doing it only specifically for the obligor and not taking into account if the custodial parent also is receiving income from independent contracting. I'm not saying put that in there, but it's also just saying that this bill as is written currently is not equitable. As an employer, as a deputy director, the undue burden on an employer to enforce this, how do you garnish wages for a 1099 is additional factors that I don't think this bill has taken into consideration for the employer, but also for the department as well. I think that we've been talking about this driver's license suspension as well as just child support enforcement for a number of years, and this bill is definitely not one that we would particularly like to support. So for that reason, I want to oppose this particular piece of legislation. Thank you.
Thank you very much. And maybe one of you, either of you can answer this. If not, maybe the administration would be able to help with this. I've been trying to figure out the correlation between non-payment and driver's license as being I guess the only way, as some see it, to get someone to comply. I just don't see the connection. I think there are different ways. I don't see driver's licenses being, and pardon my ignorance, I don't see driver's licenses as being a part of making someone, it does more harm than good. And so maybe it's time that we look at another way of trying to do it and just take driver's license out of it altogether. It muddies the water, and it doesn't do anything, in my opinion, my limited opinion, that is in any way other than punitive. And I'm glad to hear you say, Mr. Secretary, I'm glad to hear you say that we want to move away from that. And your ideas and thinking on this is just, it's great, phenomenal, and long overdue. But what is the only relationship between that and can I get the bill paid?
That is a historic lens or view of the particular department. I think the Secretary highlighted that very well, that there are other mechanisms that can be used to encourage obligors to pay their arrears, and we need to explore those. The problem is that this is out. We have this initial driver's license suspension legislation was initially introduced in 2021 following a 2-year campaign to address the particular fees that low-income workers were experiencing and that were removing them out of the workplace. I'm happy to hear that the department is willing to address this, but we don't have data. There is a joint chairman's report that is submitted 3 times a year, and none of the data that shows how many individuals' licenses were suspended, how many individuals were able to then become current from their arrears, how many individuals lost jobs. We don't have any impact data to show how effective these particular practices are, and without studying further, we cannot determine an adequate system if the other 6 ways in which they discuss will be impactful or not. And so I encourage the department to be able to sit with advocates and with those directly impacted by this legislation and their policy and practices to be able to find better ways to be able to close these gaps for our families.
So maybe that's something we can look at next year, and I'll be willing to work with you all and with the department on saying what are the other alternatives, other ways of doing it that we can maybe settle on some bill next year that we can't do everything at one time, but you certainly are bringing up some good ways for us to address this.
I would recommend that if we were to have a work group or study group, and I know that is not something that I would love to recommend, but it's something that clearly, based on the conversations that were had today, are needed. If we do not have research and data, we cannot come up with evidence-based solutions. Okay. We will just be grabbing ad hoc best practices from random places, and we don't know for sure the impact to Maryland.
No, that's fair, and I have until Friday to get that bill in. Thank you.
Thank you.
Further questions from the committee? All right, seeing none, thank you both very much.
Thank you.
All right, with that, that'll conclude the testimony in the hearing for Senate Bill 195. We'll now move on to Senate Bill 191. We're going to ask the Secretary and his panel to come on up. Welcome back, Mr. Secretary.
Hello again. This is another super easy one on change management.
Good job.
Good afternoon, Chair Smith and members of the Senate Judicial Proceedings Committee. I'm Rafael Lopez, again for the record, and I serve as the Secretary of the Department of Human Services. We respectfully urge a favorable report of SB 191, including our amendment. We are driven by 12 more Miller administration values and believe this bill exemplifies these values. Challenging the status quo is critical to reversing the practice in Maryland where youth experiencing out-of-home care stay in unlicensed settings. And let us be clear on the record, there are advocates in Maryland who have consistently and inexplicably maintained their position to advocate for youth hotel stays. A hotel is never an acceptable setting for any child to live in. To be even more clear, we should all be working to make sure children never have to experience out-of-home care in the first place. If the circumstances demand that the state must intervene on behalf of a youth, we should prioritize reunification, living with kin, and not in a stranger's home or group setting. This is what national best practices, science, and common sense tells us. I would not want either of my 2 teens to stay in a hotel, and cannot imagine you would want those for the youth you love. If it's not acceptable for my or your children, then it's unacceptable for Maryland's children. For the first time in Maryland's history, we are limiting the use of hotel stays by placing meaningful guardrails. SB 191 would codify our administration's policy against using hotel stays. The bill builds on our successful partnership with you last year when we made kin a placement preference and began to reform how we pay placement providers. Our first successful partnership was last year's passage of SB 708, prioritizing kinship care. Our new kinship licensing regulations took effect in December 2024. We can now quickly place a youth with kin, whether it's kin by blood or by choice. And why? Because family matters. Our second successful partnership with you began to reform placement provider rates. Residential child care providers will more effectively offer the services youth frequently need to prevent hospitalization or to step down from a hospitalization. The new rates also expand the array of more appropriate placements for youth in Maryland. Our next successful partnership will be holding DHS accountable to specific efforts that must be made to prevent a hotel stay in the first place. And the Maryland judiciary agrees. When we arrived in January 2023, we were outraged to learn how common hoteling had become in this state as a matter of practice. As of last Friday, out of 3,652 youth in the state's care, 29 youth were in hotels, that is less than 1% of youth in care. That is 29 young people too many, and we must continue to use every tool at our disposal, including this bill, to lower that number to an eventual 0 in the state of Maryland. We are also making an amendment to the bill on page 3, lines 27 through 28, by striking the language and ensuring payment is made in extremely rare cases when the Secretary authorizes a stay beyond 10 days. We must all envision and urgently work to create a Maryland where no youth in care are staying in an unlicensed setting for any period of time, ever. We appreciate the opportunity to give testimony, urge a favorable report, and welcome your questions.
Questions for the Secretary? All right. Sorry, Senator Henson, then Senator Sidnor, then Senator West.
Thank you, Mr. Chairman, and thank you, Mr. Secretary, for the testimony and bringing the bill. I struggle to understand how this is legal, and my concern is that we would be codifying something that would create a pathway towards making it legal. If I drive a car without a license, that's illegal. If I practice medicine without a license, that's illegal. I go hunting. We require licenses for things because it creates a legal framework to engage in that activity. How can the department place a child in an unlicensed facility and do that legally? And I don't want the bill to create a series of factors and create a pathway towards legally being able to do that.
Senator Henson, I want to answer this honestly and transparently. I don't know why Maryland has done this for years. I can't speak to why that's been the practice in the state of Maryland. It's been astonishing to watch. What we're trying to do in this bill is place guardrails around the use of hotel stays, period, and to make them non-existent in the state of Maryland. To make sure that the Secretary of the Department has the authority to engage when and if necessary. Everything that we've inherited up to this point is part of the reason why Maryland is the only state in the United States of America with fee child welfare lawsuits. The only one. The only one in the nation. The state of Maryland is the only state in the United States of America with 3 existing child welfare related lawsuits. One of them, which is 40 years old, a consent decree. So to the point that when I responded to the vice chair, we can choose to come in and do nothing and accept the status quo, or we can come in and try our best to change every single day. To give you an example on kin, which is completely related to this at its surface, one of the things we first did was understand what is the data, to your point, on what the practice is in the state of Maryland. Nationally, having run child welfare in the nation, about 35 to 36% of children experiencing out-of-home care are generally placed with kin. I would argue that's not a great stat, but it's what it is nationally. When we came into office, we learned that for Maryland, that hovered between 20 and 22%, completely unacceptable. So there was no mechanism to officially track that. We are being religious in trying to create the standard and practice to track it. Why? To make sure kin are a placement preference. We partnered with the General Assembly last year and passed that bill. Since that time, Maryland has gone from about 22% in January of 2023, hovering just under 30% as of last week. That's not a massive improvement, but it's an improvement because we're tracking it. And we're asking ourselves, why has Maryland for so long allowed this to be practiced? The same goes for hotel stays. I can't explain to you why predating our tenure, that's been the practice in Maryland. What I can say is that I've heard with my own ears and seen with my own eyes the encouragement of young people to ask for hotel stays instead of being placed with kin or others. And to be clear, for the state of Maryland, what ends up happening in terms of the data, when we looked at this closely with 2 major national partners, the Annie E. Casey Foundation and Casey Family Programs, is that for Maryland, if you enter Maryland's child welfare system on average at the age of 14, you never leave. And who has that? It's Black teenage girls. When we got that data, we said, is that okay? And the answer was overwhelmingly and profoundly, hell no. And I will not stand in my seat as secretary, in the time that I'm secretary, to allow that practice to continue. And we will do everything in our power to challenge the status quo, including some individuals who have proactively encouraged young people, mostly black teen girls, to not opt for kin, which by national best practices and the science and common sense tells us they have a better way of emerging as an adult and being connected to family, to community, and to culture.
Thank you. Is there any reason to not just outlaw, to not just outright say you cannot put our children in unlicensed facilities?
You certainly could as a General Assembly.
Okay, thank you. I appreciate your response.
Certainly.
Just to make certain I'm understanding, just following up on Senator Henson, there is a licensure process for facilities already?
Correct.
Okay, so in all actuality, what could be defined as an unlicensed setting is a setting that doesn't have a license.
Correct.
So I mean, instead of us define, because once we define it, and I think that's what you're saying, once it's defined, now you kind of have built it into the law. Thank you. You mentioned earlier, you said 29 hotel, 20, I think you said 29 hotels.
29, correct.
Youth in hotels?
Correct.
What about shelters and offices, or is that 29 across all of those?
That's a snapshot of today, not the fiscal year, though, right?
Correct, as of today.
So how many, the fiscal note says what, 200 and something?
So when the point I was making about the hotels is we've been really deliberate to bring that number down and to make sure that that is not a viable option, because in many of these cases, unfortunately, our young people have been rejected from Maryland-based providers. And so we want to make sure that we're exhausting every single possible option to make sure that young people are placed with family, that reunification is the #1 motivation to connect young people, and then placement with kin by blood or by choice. And those two tools are our first, should be always our first option.
Is the rejection from the providers a part of, or the main reason that we're dealing with this issue anyhow? Or what would you say is the issue as to why we're dealing with this?
The fact is, sir, that it is a constellation of very complicated factors. But what I can tell you is that since being office, myself and our senior team has personally intervened on cases where we've placed calls to Maryland-based providers to ask why. And so if there's a disconnect between an empty bed, and let's say it's 13-year-old Shanika, and there's an empty bed for a young woman in this particular place, we want to know why was Shanika not accepted in that bed placement. That kind of practice of having the secretary or the senior team call a provider and expect accountability for placement is not something that has been heretofore practice. So I would be remiss to say there's only one single factor. There are years of how Maryland got here to this place. But we're trying to pull every single lever to not allow it to continue.
And again, given what current practice is, your goal is to change it and start getting them back in the homes with family.
Absolutely. We're trying to do the primary prevention on the front end to never have to have this conversation, but to codify so that DHS is held accountable to not use hotels.
So,
and go ahead. My apologies.
For the children who are in these particular settings, is your office making it a priority to find the appropriate settings with their, to be placed with their families now?
Absolutely.
Okay. And I know I think it was MHA, I know they submitted testimony. Are children also being placed in hospitals?
So no child is placed in a hospital. I think maybe what's being referred to is hospital overstays. Maryland has a unique way of calculating that, which is if a child is taken to the hospital for a medical emergency or necessity, and the hospital or the attending physician declares that that person's medical need is met, how many days do they stay, for example, in the hospital past that date? What's important to also say for the record here is that we have been very deliberate in this administration to bring that number down. So as of January 10th, for example, there are 18 children in hospital overstays in the state of Maryland, 15 for psychiatric purposes, 3 for medical, 18 total of the 3,652. Much in the way I argued earlier about hotels, that's 18 children too many, but our job is to be relentless in finding the least restrictive, most appropriate setting for that child, and to make sure we're developing an array and continuum of services in Maryland to keep young people closely connected to their families, their culture, and community.
I would assume ultimately if you have those overstays, it's the state that's going to have to pay the hospital costs?
I'm sorry, I didn't catch that question.
Will the state be on the hook to pay those additional costs?
Absolutely. We pay the cost of every child.
Thank you, appreciate it.
Thank you, Mr. Chair. Thank you, Mr. Secretary. So if we were to pass this and they couldn't go to a hotel or a motel, shelter, overnight stay at an office in the department, where would they go? Are there enough spots in Maryland for them to go? And the secondary question to that is, I'm concerned of an unintended consequence where, since they couldn't go to these unlicensed settings, they could go to a licensed setting in Pennsylvania, and that takes them out of their community, near their family.
So, Senator Love, one of the things we're trying to course correct is this disconnect between the total number of beds available in Maryland on any given day and the number of children that are experiencing foster care. So let me give you 2 numbers to give you some context, because it is a huge shift in practice for the department. As of today, there are about 5,035 beds total that are contracted, any number of arrangements, ranging from regular foster care beds, kinship homes, public treatment facilities, et cetera. But there are 3,652 kids experiencing foster care right now in the state of Maryland. You can already see the disconnect. What we are trying to do is right-size the right placements that meet the needs of children. And it can range from behavioral or mental health issues, a young person that's, for example, stepped down from a hospital, to finding a place that's with kin. And I made that point earlier, which is making sure the practice of changing the way policies and practices work at all 24 departments of social service give preference to kin. That's not something that's been widespread. And we are trying to change that, which is why I was giving the example when I answered Senator Henson's question about the difference of several percentage points in increase in the number of children that are placed with kin. We want to do so much more on the front end to avoid children being in the situation where they have to go to the hospital for issues that are not medically necessary. Now, that is not in the department's direct control, but we are trying to create a system where primary prevention is the name of the game here. And what's important here is to also say, and I believe I said this on the record last year, but it's worth repeating, one of the things we were struck by was, and in my former federal role, there was a federal law passed called the Family First Prevention Services Act that specifically changed Title 4E of the Social Security Act to invest deeply in primary prevention, things like mental health services, et cetera. Maryland drew down $0 in the near decade that the law had been in place. We have been relentless in trying to reverse that trend as to why. I can't answer the why to Senator Henson's question earlier, but we can talk about what we own now, which is to make sure that the state of Maryland is drawing down every single dollar possible to invest in primary prevention in the first place. Governments are not good at raising children. Families are. And trying to make sure children do not have to experience out-of-home care, to the point I made earlier to Delegate Henson about who it is that ends up getting stuck in care. We don't want that to be Maryland's reality or its future.
Thank you. I hear that, and I understand that. I don't believe I heard an answer to my question. If we were to pass this right now, all of those children that are in these places right now, is there a place for them somewhere else right now in Maryland?
So in Maryland, I honestly couldn't say 100% yes. Our primary objective is to keep children who are experiencing out-of-home care as close to family and community as possible. That's the priority. So the first is if a child can safely reunify, and this is the case that we know they're from Maryland, that's step 1, check. That's one part of the answer to your question. The second is, if they cannot safely reunify with their immediate biological family, can we place them with kin? That's the next set. Third, if there's something else, like, for example, there are group home care settings, or depending on the child's condition, what's going on with the child, there would be options that we prioritize in Maryland first. And that generally in child welfare is called out-of-state placements. We tried to reduce the number of out-of-state placements overall. That is our administration's policy, and to only use that as a last resort. That too has been the practice of Maryland, which thankfully has reduced over the last couple of years to make sure that's not prioritized. So I would be remiss in saying to you, yes, 100%, there's a bed right now for every single child of those 29. We're working feverishly to make sure that is the case, and we prioritize in-state placement.
Thank you.
Certainly.
Thank you, Mr. Chair.
Senator James. Thank you. And thank you very much, Mr. Secretary. Just following up a little on the train of thought here about if we pass this bill, what would be, where would we be? This is a question that shows my ignorance about how your department works, but with either kinship care by blood or choice, I have a question about choice. Sure. Ultimately, does that person get somehow licensed, if you will? Is there because we're talking about licensing, so do the kinship care have to go through a process, by choice or blood, some process so that we consider them somewhat licensed, if you would?
Absolutely.
Okay. And then if by choice, can you just elaborate
Sure.
a little bit? I was trying to think like maybe a young person, they're 13, and they'd say, well, I'd like to live with.
Sure.
And you then would say, well, the process would be, let us look at your choice and see if that person would meet some criteria that comes up to the licensing standard. Is that how that works?
That's one piece of it. Yes, Senator,
Okay.
you're correct. I think maybe illustrating it like in two contexts. So I'll give the example of a colleague of mine who was an informal provider of foster care for their family member.
Okay.
They never went through the official system. Why? Because families oftentimes will take care of each other.
Right.
So the person, for example, that I consider the closest thing to my father in my life, father figure, is not my biological father.
Right.
If I were to need to be placed with someone, I would have chosen him.
Okay.
So it could be an auntie, a grandma, a cousin, a coach, a teacher.
Right.
It's who is the young person believing that not only loves and cares for them, but wants to, and how can the department, as a result of the law that you all passed last year, prioritize preference for kin so that we're working with them. And the best way to think about this is I was talking with a family member recently, and they were saying to me that prior in Maryland, we would invest a lot of time and energy on figuring out how to place, let's say, 13-year-old Mary in a stranger's home when Mary had a bunch of cousins, aunties who were willing to care for Mary. Why wouldn't I invest in your family?
Right.
And investing in your family that way is the shift now in policy and practice.
So then my follow-up is, again, sharing both of the new senators' questions. One about why, should we just it's very easy to, let's say, outlaw hotels, and yet the concern would be, well, if we did that, would we, have a terrible time with a certain small but perhaps stubborn population? I noticed on, the page 3 and 4, you go into some detail about when you're going to sort of make an exception to this, let's not put them in an unlicensed hotel. And the focus seems to be on children in need of assistance. I sort of read, I might not be getting directly, but it seems like SINA children are particularly highlighted here. So my question was, what are you trying to protect, if you will, as an option? You're absolutely against hotels. We all are here, generally speaking. But yet, and I'm not questioning this, I just want to understand it. But you are sort of saying, I'm not quite, maybe you would go along with those banning hotels, but it seems like you've left yourself some little bit of wiggle room. I want to appreciate why you've done that. What would be your concern that you want to have a little line to this as a very, very last resort, right before maybe out-of-state placement, because that would be the dead last one.
Sure. Let me try my best to answer the question as I heard it. Okay. And then, and if I didn't get the mark, just let me know. So on the issue of trying to codify not using hotels, this goes actually to the Vice Chair's earlier question on another bill, which is sort of what are the consequences of elections and appointing people, right? Governors appointing secretaries. The idea would be that the secretary has to work diligently with their senior team, and in this case, the Social Services Administration and all 24 departments to not allow this to continue. It would take some time to come back to the legislature and say, actually, I do want to place children in hotels, which, believe it or not, some people argue for.
Right.
And so we're saying that doesn't work for us. And so we're trying to codify that. Ultimately, it is the job of the General Assembly to agree or not agree and to make a decision about what we're presenting, and we respectfully will work with you to figure that out.
Sure.
Number two, on the issue of out-of-state placements, we are trying to, much more rigorously than we've actually seen in writing or in practice, understand why children oftentimes get rejected in in-state placements.
Okay.
So let me give you one concrete example that we've made a quick policy change that actually that was a bureaucratic snafu. For whatever reason, at some point in time, there was a directive to all of our staff across the state that when you were trying to place 13-year-old Mary in state, that they had to call every provider and reach out to every provider. Even if, let's say, the Shanika Henson Center does not accept girls. Why are we calling the Shanika Henson Center when it only accepts boys? That's dumb.
And we were doing that?
Oh, yes.
Okay.
Until we found out about it, me and my colleague, and we're like, that is dumb.
Okay.
We're going to change that. So we said, why are you calling for a young female 13-year-old, a placement only takes boys? How I learned that as a result was a weekend calling CEO of a provider said, why did you reject 13-year-old Mary? They said, well, because we don't take girls. I'm like, oh, thank you. Have a wonderful weekend.
Right.
Those kinds of things end up exposing themselves, and we didn't understand why we spent time there. We need to focus on the root of the issue. In this particular case, why did a Maryland provider who's contracted with State General Fund money reject our child? If they don't have, in case staff or other supports, we'll provide that staff, or we'll help you provide supports and services. We're trying to think about how to say yes to children staying in state, to the question earlier, and yes to the most least restrictive setting that's the most appropriate to children. That change is a significant lift from the practices that we've seen as we came into office.
But you may have missed my question just a little bit, and but I actually, all that really helped me too in a different way. But I look in the bill and I see that the committee, we're actively talking about, should we ban hotels, like flat out just say it, say that. And I don't know yet because I want more data, but I see that the bill has allowed for the practice to continue very stringently. You've got a lot of language in here about how tightly, how exceptional the circumstances, all the things. I'm very impressed about all the things you're going to do with putting on yourself the onus of thoroughly going through and seeing if there are any other places short of hotels. But you have not yourself put in the bill banning hotels. I wanted to appreciate maybe what your concern was, that you didn't want a flat out ban today. Maybe you'll come in 5 years, depending on where you are. I was just trying to make sure that I wouldn't go, oh, I'm going to vote no hotel because he said it was okay and the bill, you know, why should we? But you may be holding on to that option because you might need it for 24 hours or 48 hours while you get a placement, or I'm coming up with reason, or there's some unusual things that you just can't talk about today because everything's so varied. So I'm trying to understand why you've held on to the option in very limited circumstances so that we would appreciate why you're doing that.
Understood.
Okay.
I think, Senator, I think you actually hit it on the head, and I did want to reinforce the point about SINA. The entire population is SINA, which is children in need of assistance.
Right.
So that's the entire population, and ultimately we are working with the courts. For those children who are experiencing and placed in foster care. Similarly, related to out-of-state placements, and I'm going to give that example connected to your possibility because I wish I had a magic wand to correct years of these issues with our team. We don't. And we deeply rely on our partnerships with Senate attorneys, with family, with organizations, with the legal community, with the judiciary, to make all of this work. And so, for example, might there be an instance where a young person needs to be placed out of state for very severe medical needs that as of today, let's say that Johns Hopkins or the University of Maryland couldn't serve. That would be an example of where we might need some wiggle room. We don't want to have to use that option.
Right.
But because we don't have a magic wand, we want to allow ourselves the opportunity to explore different options. That's, I think, the best way to address the question.
So you'd use a hotel there for a little bit is what you're saying? Because I'm just trying to understand why you're holding on to that.
Right now, you know, there are, again, it's really hard because ultimately, we want to restrict the use of the hotels in general.
Sure.
That's the bottom line. And to put some guardrails around if they were to ever be used, why?
Okay. So you do want to hold that option for those, because you're trying to say, I can't anticipate every single scenario
That's
that
exactly
could come
right.
my way.
That's exactly right.
So this is not our practice, this is not our goal, we want to get it to zero. But if I eliminate it completely, would I somehow cause a bad situation for a particular child where I am, you know, at my wit's end and maybe have to send them out of state when I'd rather keep them in a hotel for a couple of days and then get them? Is that sort of your thinking? And then I'll stop, because I'm just trying to really understand why you're holding on to it.
Senator. Yeah.
So that when we debate it, when you may not be in the room, that we understand why you held on to it in case we do start going to the no hotel.
Understood.
So, and you can follow up later if you want to get back to it.
We're happy to.
Okay.
Only because I think there's different scenarios. Because if I've learned anything and my team has learned anything, every single child is a single child with their own important nuances to their experience. And the question for us fundamentally, bless you, is when they are engaging with our department, how might we serve them better? How might we make sure that they're better off and that we're providing a kind of world-class service that perhaps they haven't always experienced in the state of Maryland? That's the motivation ultimately behind all these reforms. Sure. And to the question earlier, I forget who asked it, we're trying to focus our work on the primary prevention side to never have to get to that point. It's going to take us some time to get there, and the reforms that we have begun to put in place from the moment we came into office, codified. I gave you the example of kin, for example, the kinship law. Those things take time. We just literally went around all 24 jurisdictions and trained up all of our team members across the state. Is that perfect? No, but it's better than a year ago. Certainly better than we found when we walked in the door, and that it was commonplace to not always prefer kin. So we're trying very, very hard to pull these multiple levers, Senator, to make sure we don't even get to the place of hotels.
All right, thank
Certainly.
you.
Senator West and Senator Golden.
Thank you, Mr. Chair. So I've got a piece of paper here produced by the Coalition to Protect Maryland's Children, and they advised me that last year, 235 children were placed in unlicensed settings for an average of 78 days each. Does that sound correct to you?
Not exactly. I'd have to look to see where that data is coming from. So let me see so hold on one second.
I don't need to know if it's exactly correct.
Well, I do have.
Is that in the ballpark of being correct?
Ballpark, yes.
Okay.
Because ultimately I have the average length of stay per fiscal year. Is that what you're mentioning, sir?
No, I'm just trying to quantify the problem. So last year we had 235 children, give or take, for an average of 78 days each, give or take. So that's a lot of days kids are in unlicensed settings.
So correct. Let me actually hold 1 second. I want to reference in this point the average.
So Senator West, the information provided from the department in our fiscal note says that 73 days, not 78 days. Right. It's 235 children. That information provided by.
Again, I'm not asking you to give me specifics, but.
I can give the specific for right now to give also some context. So, for example, as of the 10th of January of this year, I mentioned the number 29 currently active in hotels, and the average length of stay for all those hotel is 55 days. Okay. There are varying numbers. Some are much smaller, some are longer, as the department works diligently to find a more appropriate placement for the child.
But it's not the department that makes these placements. These are courts across the state that are making these placements, correct?
No, sir.
Oh, I thought where are the
local departments of social services in whose care and custody the child is working closely with the array of providers.
Don't the Senate cases come to courts?
The child is a child in need of assistance because a court has deemed them to be such.
Okay. And doesn't the court make the decision where the child's going to go? Or is that a local social services department?
It's primarily a local Department of Social Services decision, which is part of the Department of Human Services.
Okay. So So this isn't, how do the local departments get these? Isn't it your agency's responsibility to provide these options to the local departments? Or is, for example, just taking into account, is the Howard County Department of Social Services responsible for finding placement locations in Howard County?
Senator, you're actually hitting the nail on the head on one of the things that we've been course correcting since coming to office. I just testified in court last week for several hours on 2 particular cases. Why I went and was to show the judge that we have been much more deliberate about making sure we have streamlined and consistent services across the state. Oftentimes we've learned that individual counties were oftentimes left to their, to negotiating individual, let's say, placements and weren't always working as closely with the Social Services Administration and the department as they could and should. We are trying to reverse that pattern and practice in the state and be very proactive so that staff in the central office, as it's called, in the Social Services Administration is partnering with the local Department of Social Services staff who's vigorously trying to find a placement and making sure that we're looking at every single option.
Okay, so
ultimately,
it's not your responsibility at the central. Where's your office, in Annapolis?
Baltimore. I have them in all 24 jurisdictions, but Baltimore is where the primary one is.
But it's not your agency's responsibility to locate these placement locations. It's the local Department of Social Services that's responsible for that?
So I'm gonna answer it this way, sir, because this is the way I see it. It is our job.
Okay.
And I always say that, the lawsuits don't say v. DHS, they say v. Lopez.
Okay.
There's a federal rule that changes whenever the secretary comes in, that's who the lawsuits are against. So it is our job.
All right, well, I'm looking at the bill. You've asked us to pass a bill, and the bill says a SINA may be placed in an unlicensed setting if the agency responsible for the placement and care of the child documents and demonstrates by clear and convincing evidence. I'm a lawyer. That's a legal standard which normally is used in court. So is it your contemplation that if this bill is passed, and just to use my hypothetical, the Howard County Department of Social Services is going to have to go into some court in Howard County and demonstrate to the judge by clear and convincing evidence that certain qualifications have been achieved?
The quick answer is yes, sir. That is the way the current child welfare system in Maryland works. And when the county LDSS goes in to defend itself, generally speaking, it is the Office of the Attorney General, our lawyers, helping defend the local department on behalf of the Department of Human Services. That is correct. That is how it works.
So it is a court that makes the decision at the end of the day. It's not in order to get the court to make the decision under this bill, the local Department of Social Services is going to have to establish, I guess by evidence, to the satisfaction of the court, by clear and convincing evidence that these criteria have been achieved. And then the court will make the decision where the placement occurs under this bill, right?
Sir, that's not the way.
That's how I read the bill.
That's why I need to take another look in that. I want to work with you about your reading of the bill. That's not the way we intended it to be, because a court in Maryland doesn't place the child.
Well, under this bill, that seems to be what the bill contemplates.
Can we just, I want to just streamline this, because it seems like what you're getting at is, it seems like this is purely an administrative function, not involving a court, okay? And so when you're talking about invoking a new standard, this is an administrative process, not a court-driven process. It seems like you're the one replacing these children in
We are, correct.
Yeah, you're not seeking a court's guidance for this.
Not for the placement,
so then who is the arbiter of the standard?
Right.
Because it seems like it's purely an administrative function. And so I guess that's where your confusion is arising.
It looks like somebody has to go to court and demonstrate by clear and convincing evidence to a judge that certain criteria has been accomplished, and then the judge would decide where the child is placed. But if that's not the case, then I think we need to rewrite the bill.
We'll take another look, sure.
Okay.
And if they run afoul of this administrative piece, then if their child has an advocate, can they challenge it? And do they go to court to challenge that you haven't adhered to whatever the standards are internally for the administrative piece? I don't know. I don't know the answer to that question.
I think the senator brings up a good point. We're happy to take another look in terms of that interpretation. That's not.
Whoops. There we go. I'm back on. My second issue, and I hate to keep harping on this, is fiscal. We're having a serious fiscal problem this year. So the state fiscal effect on page 4 of the fiscal note indicates DHS notes that potential annual costs associated with unlicensed placement of contracts can range from $2.3 million to $7.9 million. And this organization has done their own computation and said the cost could be as high as $25 million. That's a huge amount of money.
These hotel stays have been unbudgeted. Until we asked the question, how much are we spending here? There wasn't a mechanism to track these. All the calculations we've hand-pulled, calling our 24 departments of social services. I would argue that's not a way to run a multi-billion-dollar agency. That has been the practice in Maryland for years. And what we're saying is we should not have these kinds of unbudgeted expenses. We should be deliberate in terms of not only how we're budgeting, but how we're prioritizing children to be placed in the most appropriate, least restrictive setting, preferably with family or kin by blood or by choice. If we do that more effectively, we will not be spending general fund money on the costs to have a child experiencing out-of-home care in a hotel.
Well, let me finish by asking.
Certainly.
So you're now entering on your third year of being in charge of this system, and you don't think that we should be putting kids in hotels, and I agree with you. But why hasn't, I would assume your department has made lots of efforts to try to find other locations better than hotels, and having not succeeded, what is this, how is this bill going to change things? If it's your job to find these other locations, this bill doesn't seem to be advancing the goal of finding other locations. This bill basically says a court can't do it. Aren't you putting these kids in between a rock and a hard place? If the court can't put them in hotels and you haven't found alternate placement locations, what's a court supposed to do?
Right. Well, you know, this is the conundrum that we've inherited in Maryland. And I would argue that what we're doing every single day is trying to turn around the practice to do things differently. So one, I will say, and it's worth repeating, doing everything we can to focus on primary prevention, to not have children experience out-of-home care in the first place.
Well, then let me just conclude by saying I'm reminded of Chief Justice Roberts' statement that the way to solve discrimination is just not to discriminate. And so instead of passing a bill which puts kids between and courts between a rock and a hard place, wouldn't the way to solve this problem be for your department to spend this money to find other locations, better locations than hotels, where these kids can be placed?
That's exactly right. That's what we're doing.
Okay, thank you.
Certainly.
Thank you, Mr. Chair. Mr. Secretary, just real short and simple, it's kind of a yes or no, but by passing this type of bill, would this body, the General Assembly, be giving a blessing to a practice that even all of us and you seemingly say is wrong?
Can you please repeat the question? I want to make sure I get it right.
If this body took this bill up as it's written and we were to pass it, would every member of this body, and including you as a secretary, basically be blessing the very thing that I think we've all agreed and you said is wrong?
Understood.
It's a simple yes or no.
No, because how we interpret the bill.
Okay,
No,
agree to
I
disagree.
answered you honestly. I guess
No, it's a simple yes or no, because if we pass the bill, then we're passing and legislatively putting in codifying in law a process that we're all saying should never exist.
But it does in Maryland, and I'm trying to help change it. No, I agree with you.
And if we, and this, by doing this, you're codifying it now, whereas we should be doing something to eliminate it.
And we are working feverishly to eliminate it. Thank you, sir.
Yeah. Sorry, Mr. Secretary.
No, sir.
You're, okay, excellent. All right. So further questions from the committee? Let's have a couple of just clarifying ones that kind of follow-up questions from a lot of the senators that come up. So for their current stock of unlicensed stock, right? What's the number? Like how many slots, for lack of a better term, are there through all the contracts that you have? How many spaces are there for the children?
Oh, understood. As of today, 5,035 beds in the state of Maryland.
Okay.
And those are a range of types of contracted beds.
Got it. And then you said there like currently 3,000 or so are kind of are
3,652 children currently as of January, I want to say 10th, I could be wrong.
So there
January 10th, 3,652 children experiencing out-of-home care, correct?
So there are 1,500 or something like that that are out there hanging that are available at this moment in time.
Correct.
And then you combine that with your I know you're taking the proactive measures of kinship placement and all that stuff. So the question is, so why, then this is your department's numbers, there were 234, average of 73 days of people placed in these hotels, which are unlicensed. So what's the reason for that gap?
There are a range of reasons that can range from a child being rejected from a placement in a particular home or a provider, or that child, for example, might have been at a particular home and the placement didn't work out. There's a number of reasons, but what I ultimately in our department is trying to do is not ever blame the child, but to actually say it is our job to make sure we have a continuum of services to make sure we're providing the right placement for the right child at the right time. Course correcting years of this disconnect between the total number of kids in care, total beds available, and the type of placements, like the right step-down facilities for children leaving hospital, for example, is something that we are desperately working on 24/7.
Got it. For unlicensed setting, the bill has like language that is, it says includes, hotel or motel, three basic categories: shelter designed to meet the needs of the child who has run away or is homeless and the like. Is that exclusive, or is that an exclusive definition? Because it's awkwardly phrased in terms of how I would interpret it, or like
right.
So because sometimes we always add language that says or any other ...
Understood.
So it's more open-ended. Is this an exclusive definition of what an unlicensed setting means, or is just an example?
It's an example, and I think ultimately, based on the kinds of questions we're getting today, we'll have to take a second look at that and make sure that we are being as thoughtful as possible, and also working with anyone who wants to offer amendments. If any of you believe that we can strengthen the language or change the language, we're open to those kinds of suggestions.
The last question is,
certainly.
So hospital stays, so the state pays for that?
Any child who's in the care and custody of the state of Maryland, ultimately we pay. Absolutely. And in many cases, though not always, the child generally is covered through Medicaid.
Yeah.
But oftentimes, if there are other extraordinary needs or circumstances, for example, if we have to use an out-of-state placement because the placement is closer to kin someplace else, let's say Pennsylvania or West Virginia or Virginia or DC, and there are additional costs, we ultimately pick up that charge and do so absolutely willingly because it might be the most appropriate placement for the child at that time, particularly in the medical needs situation.
Good. And then there are a couple of amendments up front, but the escape valve language that Senator James walked us through, which is thorough, but then you have amendments that say that that the state you're striking the language that says the state may not pay in the case this escape valve is exercised. So then if there's a $2 million fiscal note associated with this, or maybe ballpark it, like it's going to cost more than that if you exercise this escape valve. And then if we preclude paying for it from the state, who does pay for it? Like where does that money come from?
That's partly why we struck it. Our intent wasn't to use Senator James's language to put sort of the child or the courts in a rock and a hard place. That's not the intention here. And so we want to make sure that we're doing everything possible and to make that the exception. So ultimately, the state, as I mentioned, had not previously tracked these kinds of expenses. To give you one concrete example, we spend millions of dollars on what are called one-on-ones that are placed to make sure that children get the care they need. All of that is coming from state general fund dollars. And when we take a look at all of that, all of those expenses, we'd rather focus that money on the front end to prevent children from staying in care longer than they need to.
No, and that's why I mentioned like the 234 number.
Understood.
Because obviously, like even with those preventative measures being exercised, you're still ending up with 200 plus kids for 73 days a year, ending up in these facilities, in hotels. Look, I'll just end with this. Like, obviously none of us want hotels or unlicensed settings to be used, but I think it is an important question that Senator Henson, Senator Love, and Senator James brought up about, and Senator West, about, what next? Like what, I think it's a significant problem, worth all 11 of us thinking about. Okay. Well, thank you very much, Mr. Secretary.
Certainly.
We'll next hear from our guest who's visiting us virtually, Ms. Caldwell. Thank you for your patience. You're up. Welcome.
Good afternoon, everyone. Thank you very much. I'm a grandmother fighting very hard for my 13-year-old grandson who suffers with multiple mental illness issues and autism. DSS had him in several hotels in Baltimore County and Baltimore City area for about 15 months. During that time, he was unable to get into any therapeutic residential treatment facility because there are only a small number of centers in the Maryland area for children. There are thousands of children living in hotels in the state of Maryland and across the country. These children are not receiving any therapy treatment in these hotels, no physical activities, no proper nutritional meals daily, just stuck in front of a TV playing video games all day and all night just to keep them quiet. My grandson is spiraling out of control because of being in one of these situations. He's cursing more, he's more aggressive, very disrespectful, and now not living in a structured environment on a day-to-day basis. DSS found a place for my grandson called Wellborn in Baltimore City, but they failed to complete the admission package. The bed was given to another child. Then I told DSS about the children's home. They dragged their feet again about applying for services for him. I kept begging them, and they finally filled out the application. He was accepted. He was there for about a month and a half, and the center threw him out a few days before Christmas because of his behavior and not living in a structured environment over a long period of time. Then DSS threw him into an adult group home in Northeast Baltimore. There is no phone in this house. I have very little communication with my child, not sure of his safety or his well-being. My child needs therapy to help with his behavior. I am asking the state to open up more therapeutic mental health facilities for our children and get them out of these hotels. You have shut down areas in Arbutus, Hagerstown, and other facilities in the state of Maryland that need to be open now. Please, we are in a crisis situation with our children. They need help now because they're spiraling out of control. We need help now and for the future. Please make this a priority in your next voting session. Thank you very much. I'm Diane Caldwell.
Thank you very much, Ms. Caldwell. Thank you for joining us, and thank you for your patience. Questions from the committee for Ms. Caldwell? All right, thank you very much.
Thank you.
All right, with that, I believe that will conclude the testimony for the proponents of the bill. We'll now switch to the opponents or the opposition. And if Ms. Berger here? All right, so Ms. Berger, Judith Shangren. And then the rest are virtual. So please, if you could take the podium when you've been testified.
Good afternoon. My name is Megan Berger. I'm the legal director at Disability Rights Maryland, the state's federally mandated protection and advocacy agency, advancing the civil rights of people with disabilities. We regularly advocate for children in DHS care and custody who are stuck in unlicensed and illegal placements and settings long past their discharge date, and we're co-counsel in a lawsuit against DHS on behalf of a putative class of foster children who have experienced hospital overstays. We oppose this bill for several reasons, many that have been alluded to here. So we're concerned that the bill attempts to legalize the placement of foster children in unlicensed settings and immunize the state against liability under the Americans with Disabilities Act for placing children in unlicensed settings that are overly restrictive and least like a family setting. I know everyone in this room is concerned about hospital overstays. and unlicensed settings and children being stuck in hospitals, motels, DSS offices. Everybody wants to fix the problem. On its face, this bill may seem like it's attempting to limit the use of unlicensed settings, but when you drill down, the actual outcome is that it would legalize unlicensed placements by allowing DHS to seek juvenile court approval of the unlicensed placement by documenting its failed efforts to place the child. We strongly believe that youth with disabilities have the right to live and thrive in their communities. And under the Americans with Disabilities Act, DHS is required legally to place foster children in the most integrated setting appropriate to their needs. This bill creates an alarming end run around the ADA by allowing DHS to seek an order from a juvenile court finding that a foster child can be placed in an unlicensed setting because DHS has attempted to comply with the ADA but failed because of the lack of sufficient community-based placements. The true root of the hospital overstay problem is that there aren't enough community placements for children. At the end of the day, the state needs to be focusing on developing and funding additional placements for children in the community, foster homes, group homes. And lastly, this bill falls short of that, and it's attempting to legalize what at its core is illegal, and our youth deserve better. So thank you. We ask you to issue an unfavorable report.
Thank you very much.
Good afternoon, Mr. Chairperson and members of the committee. I'm here today on behalf of the Coalition to Protect Maryland's Children, urging you to oppose SB 191. I'm a retired social worker, Judith Shagrin, with decades of public child welfare experience, the last 20 administering a large county's foster care program. As a result, I had a front row seat to watching the placement crisis unfold. Hoteling began in 2018 out of desperation after hundreds of beds closed, including roughly 5 residential treatment centers. Recent data indicated that 60% of youth who are ages 14 to 17 are entering care not for traditional maltreatment reasons, but to meet behavioral health needs. Those are children who are difficult to maintain in a family, and we no longer have therapeutic placements for them. I'm not even going to go into how horrible hotels and office buildings are. I think we all agree on that. The bottom line is we need appropriate placements to meet the needs of the children in our care, and this bill doesn't do that. A colleague had a saying, when we're treating someone else's child in a way we would never treat our own, we need to stop and ask why. I'm sure we can do better, and this bill does not do that. Thank you.
Senator James. Thank you, and for either or both of you, now that I've got some clarification through many excellent questions, I think what I'm hearing is that we lack information, because we seem to have a mismatch. We seem to have well over 5,000 beds of some sort, which I assume is kinship, by choice or blood, and on down the line. And then we have about 3,600 children. But without data to see why, with all that capacity, we still use unlicensed hotels, I think without us having information, and so I'm asking you ladies if you know, what is the nature of these 250 children? And let's just say it's I don't know how long that number has existed. And, why do they have this duration of 70 days, and what happens to them after the 70 days? Do they find an appropriate place, or does something else happen? So I feel very handicapped at assessing the bill without having some data. So my question to you all is, do you know of data that would help us understand these numbers being bandied about, the 5,000 versus 3,600 children, and this 250 range population, and the 70-ish days of stay? Without that, I don't know if we would know how to craft a bill. Do you ladies have any information on this? And I should have asked the department, but I don't know if they could speak to it, but I would ask them to give us information if that is available, so we have more information. Thank you.
I don't have exact data, and it was helpful to hear the numbers today, actually, about the kids in overstay and in hotels. But we do know that this problem has been years in the making. There is a placement shortage. There are not enough community-based placements. There aren't enough foster homes, community group homes.
How can you say that? You say they're not. Sorry to interrupt, but I want to make sure we stay on. We have a lot of capacity, and yet I'm not disagreeing with you. You're saying we don't have enough placements. So where's the mismatch between the 5,000 beds, the 3,600 children? Where do we not have enough when we have 1,400 beds available somewhere? And it's okay if you don't know. I would just like follow up after the hearing for the proponents' input.
Yeah, I think that the department can certainly answer. I mean, that's something that we need placements across the continuum, but in our assessment, what we most need for kids is community-based placements and also preventive and wraparound services so that they're receiving those services when they're in a foster home. So if there is a behavioral health crisis, those services are in place in the foster home, and it prevents that emergency in the first instance.
And because I'm not familiar with the lingo here, community placements, we have over 5,000 beds. I have no idea what kind of beds those are, and I don't know if they fit the definition of community placement. So when you use community placement, what do you mean in lay language?
Sure, I am referring to foster homes, group homes, certainly residential providers in the community. I'm not referring to residential treatment centers or institutional settings or out of state.
Nor kinship care, is that correct?
Right, and we 100% support the department's efforts for reunification and kinship care, but that's not what this bill is. That's not what this bill is about. And I don't know if the department has specific answers about the numbers of each of those types of places.
The bill may not be about it, but it touches on it, because if there was enough kinship care, blood or choice, then we would not have 250 people in hotels, right? So, I mean, there is some touching of that issue.
So again, what I would want to point out is what the data does show is that 60% of youth that are in care 14 to 17 have high-intensity behavioral health needs. And so, in fact, if kids were widgets, it'd be so much easier.
And that's the only thing I was trying to get to, Mr. Chairman. For all of us, I think we need some data. Now I think this bill should be a study, because I don't know what the problem is. I'm beginning to hear it. This may be a very difficult population, right. Not blaming the children, but it's a difficult population to provide for, to help through a lot of things that have come before. And that may be the issue, so that if we knew what the population generally was, with some exceptions, we might be able to better craft legislation if it is all necessary, because maybe putting a law on yourself is not the answer. Just do what you need to do. What was it? Don't discriminate. If you don't want to discriminate, don't discriminate. But, okay, thank you, Mr. Chairman.
All right, seeing no further questions from the committee, thank you both very much. So that will conclude the testimony for the opponents, and we'll now switch over to, actually we have two joining us virtually. We have Ms. Jennifer Stein and then Mitchell Mervis. So Jennifer, you're up next. Welcome.
Thank you so much. Thank you, Mr. Chairman. Thank you, members of the committee. Appreciate you letting me speak from afar. I am Jennifer Stein. I'm a member of the Coalition to Protect Maryland's Children. I'm also the executive director for Court-Appointed Special Advocates of Baltimore County, also known as CASA of Baltimore County. We are a nonprofit that provides mentorship and advocacy. We are on the ground every day working with these youth that are impacted by this placement crisis. We agree wholeheartedly. I've been advocating for payments for kinship providers. We agree with all of that, but I also agree with Ms. Shagrin that this population is not necessarily going to be addressed by that particular solution. And I have serious concerns that this bill simply sanctions something that is an unsafe practice. The bill doesn't offer any solutions and doesn't really do anything new that I can tell, as in the fiscal note, it acknowledges that the department is already making every effort to place children in safe placements before they resort to a hotel. It also doesn't offer any protections for the children when they are having to be placed in the hotel settings, or for the aides that are placed with them, living 24/7 in a room with a child who may have severe behavioral or mental health issues, medications that are, unlocked. There are just a whole host of concerns. And then, of course, there's the question of cost. We've heard this before today, that the cost to the state is enormous for this setup, including the one-to-one aides and the hotels and the food and all the other ancillary items. It's actually less expensive to try to create placements that are appropriate for the youth and are able to meet the severe needs that these youth tend to have. I do agree wholeheartedly that a bill is needed. I just don't think that this is the one. I would love to see the department engage with others on the ground, the coalition, to create a bill that actually has solutions included for placements that are appropriate for the children that need them. So I would ask for an unfavorable report on this bill. Thank you.
Thank you very much, Ms. Stein. Thank you for your testimony. Mr. Mervis, you're up. Welcome.
Thank you very much. Mr. Chairman, members of the committee, my name is Mitchell Mervis. I am an attorney at Venable LLP. I am co-counsel and have been class counsel for the class of Baltimore City foster children in the LJ versus Lopez case since 1988. Also, I am co-counsel with Disability Rights Maryland in the TG case, which addresses hospital overstays for all foster children in Maryland outside of Baltimore City. The LJ case is Baltimore City. It has a modified consent decree which prohibits the placement of any foster child in any unlicensed facility, including DSS offices, including hospital overstays, including hotels. We have been trying to get this practice stopped for the last 6 years. To no avail. This bill will do nothing to fix the problem. In fact, as we see it, the purpose of the bill, or one of the principal purposes of the bill, is to create judicial findings that will, in fact, justify the illegal practice. Moreover, one of the provisions of the bill, this is lines 19 to 20 on page 4, would have a finding of reasonable accommodations that the department absolutely would try to use in our federal case, the TG case. They lost a motion to dismiss. The state argued, oh, the juvenile court will take care of it. What they want to do is get findings by the juvenile court that would allow them to defend and defeat that lawsuit, basically scuttling the civil rights of the most vulnerable population of children in the state. This is a terrible bill. The problem is lack of placements. I can answer the question, I think, as to the disconnect between the 3,600 kids and the 5,000 beds. Those beds, as I understand it, many of them are not actually available due to staffing issues. Those are licensed slots that could be available, but the number of actual beds that are available is much, much smaller. If you talk to the providers about the problem, they say they are saturated. They do not have beds available for these children. The children also are not just 14 to 17 or even older. It's a widespread spectrum. Some are medically fragile infants, have been stuck in hospitals for weeks and months. The average age of kids in Baltimore City, according to our most recent filing in the LJ case, was approximately 13 years old, was the median age. So it's a wide spectrum. There have been 6 to 10-year-old kids stuck in hospitals, hotels, et cetera.
Thank you very much. Questions from the committee for Mr. Mervis or Ms. Stein? This is very good testimony. Thank you. A lot of good information and context. Thank you both. Also, thank you for your backgrounds, because that's literally the only way I can tell it's still light outside, because I've been here since we got off the floor. It feels like I'm in a black hole sometimes, so I appreciate that. All right. Hey, thank you both very much. I have a feeling we'll be in contact with both of you as this debate continues. Thank you all. All right, with that, that'll end the testimony for the opponents of the bill. We'll now switch over to an informational panel, and we will start off with Is Rachel Burrow Hernandez here? And then we'll move on to Megan Perlman, Melanie Lee, and Lauren Fitzpatrick. Any testimony?
Mr. Chairman, I'm with the Maryland Hospital Association. Could I come with this panel as well? Sure. Thank you. Good afternoon, Chairman Smith, Vice Chair Waldstreicher, members of the committee. My name is Jane Krinke. I'm here on behalf of the Maryland Hospital Association and our 60-member hospitals and health systems. We're here to provide information on Senate Bill 191. First, we'd like to thank and commend Secretary Lopez for bringing this bill forward. We agree, as many of you do, or all of you do, that children and youth should not be placed in hotels, office buildings, or shelters. These should not be long-term placement options. Similarly, hospitals are not licensed for the purpose of being a long-term placement option for children and youth, especially those in need of a therapeutic environment. We really have a crisis in the state. I think you've heard from the advocates, and this has been ongoing and worsening. We simply do not have enough behavioral health placement options to meet the needs of these kids. And as a result, these children and youth are actually living in hospital emergency departments. They're living in inpatient units. They're there for days, weeks, months, even up to a year in some cases. As you'll hear from our panel, they'll explain what it's like to live in a hospital environment, how detrimental it is to the child, their family, the staff, everyone involved. Without increasing behavioral health capacity for placements like residential treatment centers, we're going to continue to see these unlicensed and inappropriate placements. There's just nowhere else for these children to go. We've requested legislation to be introduced this session to help address the capacity issue and help improve this broken system that we're all working within. I have a little bit of data from some data surveys we've done in our hospitals. We only have about 26 per reporting now, but as of January 9th, we have 44 pediatric overstay patients in the state. So this includes kids that have been in the emergency department more than 24 hours or admitted to an inpatient unit beyond medical necessity, meaning they have been cleared for discharge, but there's nowhere to go. 66% are between the age of 13 and 17. 75% are involved with DHS or local DSS. 23 out of the 44 who are school-aged are not in school, and 57% are waiting for an RTC. So happy to answer any questions or provide additional information. Thank you.
Good afternoon. I am Dr. Lauren Fitzpatrick. I'm the medical director at the combined pediatric inpatient and ER at Anne Arundel Medical Center, Luminous Health. Thank you, Senators, for your time for this very important issue for some of Maryland's most vulnerable children, and special congratulations to Senator Henson as you represent us here in Annapolis. Less than 5 miles away from this very Senate building are and have been children sitting in a 4-walled emergency room with small windows that let in some light, but deprives children of fresh air and peer interaction. Now imagine being trapped in that room 24 hours a day for 12 weeks, over 90 days, of which insurance only pays one of the 90-day stay. Imagine you're a 12-year-old boy who was brought in for being aggressive, already feeling rejected because you were not placed with your biological family, and now being told that there's no opportunity for placement in a group or foster home. No one can tell you what your fate is. All you know is you missed the end of summer, days at the pool. You started the school year in a hospital. You've missed over 90 days of educational learning. You miss fall sports, school field trips, Halloween trick-or-treating, Thanksgiving meals, haircuts, long weekends, birthday parties, and hanging out with friends. The list of opportunities robbed from these children is long, and the wait for placement is even longer, without any semblance of normalcy, which we cannot recreate in an emergency room department. While we can all agree that hotel stays are less than ideal for our most vulnerable population, this bill is limited as it does not provide a solution, and ultimately pushes more and more children into placement in the emergency room, where actual medical care is supposed to occur, and then is delayed because we are busy housing youth. Limiting the opportunity for hospital stays without any other solution to address this dire situation facing Maryland's most vulnerable youth creates a myriad of other problems. Please consider legislation that actually addresses the problem rather than compounds it. Thank you.
Good afternoon. I'm Melanie Lee. I'm the Clinical Nursing Director for the Pediatric Emergency Department and Inpatient Unit at Luminous Health Anne Arundel Medical Center. Thank you for allowing me to come and share some information. Our current state at the moment is that we've had a child in our Pediatric Emergency Department who is currently under PG County DSS for 41 days. This child is not an option for reunification, next of kin. There's no options of these 5,000 contracted beds this patient has been denied from. This patient has nowhere to go. 41 days in a room that is simply a TV and a bed and a frosted glass window. 41 days of no other interaction with peers, no exercise, no school, no outlet to outpatient services. As a nurse of 21 years, it feels criminal to keep a child in a pediatric emergency department. I acknowledge that housing use in hotels is, nobody wants that, and that's not the option. But essentially abandoning a child in a pediatric emergency department is not the solution. I feel this bill is really not addressing the placement option deficits that we are currently facing. And if we remove, while it's not a good selection or a choice, the ability to send a child to a hotel, we are essentially saying those children currently in hotels will be brought to the pediatric emergency department. And while the government is not the best at raising children, either is a pediatric emergency department. So, you know, I thought it was really telling as I round on my patient that's been with us for these 41 days, and she told me literally this week, Miss Mel, this is so unfair to me that I'm stuck in a room. This is unfair. Like, I want to go back to where I was. She was currently staying at a hotel in Baltimore, but at least there she could go outside, go to the gym, and actually cook her own food. So, thank you.
Good afternoon, Mr. Chair and members of the committee. My name is Rachel Borer-Hernandez, and I'm the Director of Pediatric Social Work at the Johns Hopkins Hospital. For a moment, like the others, I'd like you to take a minute and imagine being placed in a room that is 8 by 10 for an indeterminate amount of time, having one outfit, one pair of underwear, and no access to anything that may comfort you. During this time, you're not able to see the sunshine, we don't have windows, feel the fresh air, eat any junk food, spend any time on the computer or your cell phones or playing your beloved video games with your friends. To make things worse, you're not attending school and you're not able to get any type of therapeutic interventions. You may have a one-on-one assigned to you, but you're so angry that you take your frustrations out on them and end up having them sit outside with a security guard. Also imagine that your shoes are taken as a preventative measure to keep you from running away. Your DSS worker barely calls you, and when they do, there's no good news. Would you feel like a prisoner? Would you consider this humane treatment of a child? Would you want your child or any child to be treated this way? Last year, in the Johns Hopkins Children's Center, we had 25 children in this situation, 806 days, meaning they were in the hospital beyond what was medically necessary for 806 days. All of these children had DSS involvement and were eventually placed in a DSS placement. I wholeheartedly agree that children do not belong in placements that are unlicensed and inappropriate for their well-being, like hotels, motels, and offices. This list also should include hospitals. Hospitals are meant for short-term treatment of acute medical needs. We are taking care of the most critically ill children at Johns Hopkins Hospital. When DSS utilizes our beds for their placements for 806 days, we often have to make sick children wait for beds. We have worked with DSS and DHS over the years to find appropriate placements and try to develop an efficient, effective workflow to place the children. However, far too often, these children are caught up in complicated bureaucratic processes. Overstays are a direct result of the complexity of care needed and the state not having enough placements. And I heard the buzzer, so I'll stop. But if you have any questions, I'm more than happy to answer.
Appreciate it. Thank you very much.
Thank you.
Good afternoon, Mr. Chair, Vice Chair, and members of the committee. My name is Megan Perlman. I'm the manager of social work at the University of Maryland Medical Center. I've been a social worker for 14 years, and 12 of which have been in the hospital setting. At UMMC, on any given day, we serve typically about 150 children. Some of these kids are children in need of assistance, but they end up in our hospitals medically unnecessary. I agree with the department and those that have testified before me that hoteling is not the best practice, and we support improving kinship care, but leaving children in the hospitals is not the answer. Over recent years, we've seen a significant increase in the number of children being left in hospitals without medical necessity. This places a heavy strain on medical resources, disrupts hospital operations, and most importantly, denies children of the stability and care that they deserve. Many assume hospitals are places of rest and recovery, but the reality is far different. Most days are filled with sounds of equipment beeping, families grieving. This is not a place for a medically ready child who should be at school with their peers, experiencing milestones of that with their peers. I also strongly agree that kinship placements are underutilized, and on many occasions for the kids that we care for, they have family members or friends that we would identify as family members who want to care for them and whom they want to be with. More often than not, we are identifying individuals to the state case managers, but they rarely do end up being placed in kinship care. In the 6 years that I've been at University of Maryland Medical Center, I'm not aware of any of our kids going into kinship care from our hospital. Thank you for the time that you've allowed me today to share information about how this impacts children and our hospital system. Thank you.
All right, thank you all very much. Questions from the committee? Panel. Senator Sidnor.
Just one question for the last panelist from University of Maryland. You had mentioned, you said they should be in school. I'm curious, when they're in the hospital for these prolonged stays, do they not get any schooling? Would you mind going to the mic?
It's not the traditional sense of school. They might have an hour with a home and hospital teacher that will come to the bedside, which is nothing like the real school experience, being with your peers, going to different classes, getting in classroom experience. It's not the same.
And are they essentially stuck in the room, or, I mean, do they go outside, or, I mean, what?
No, they're in a room.
Okay.
We don't have outside space.
Thank you.
Further questions from the committee? All right, before we let the panelists go, we have one more guest joining us virtually. So Haley, how are you? Thanks for your patience. Welcome. The floor is yours.
Thank you, Mr. Chair and members of the committee. My name is Haley Lichterman, and I am the Deputy Chief of the Parental Defense Division at the Maryland Office of the Public Defender. And I have submitted informational testimony and had originally planned to just rest on that testimony and be available to answer questions. I did, after reading some of the oppositional testimony, want to make a few additions to my written testimony. From our conversations with DHS and listening to the Secretary's testimony today, our understanding is that the intention of this bill is to minimize or limit the use of unlicensed placements. Our concern is that the way the bill is drafted actually creates a mechanism for the court to sanction these placements, and as of now, the law does not allow for that at all. We share the concerns regarding hospital and psychiatric overstays, and we're also concerned that by defining unlicensed placement, while it doesn't specifically state that a psychiatric or hospital setting is an unlicensed placement, the bill, in the way it's drafted, leaves room to interpret it that way. I just also want to emphasize our suggestion that an actual potential resolution to this ongoing problem is to provide more support, specifically financial support, to families and kin to help keep children out of these types of placements. These unlicensed settings are amongst the most expensive to the state, and so not only would it do what's best for children, but it would save the state a lot of money. So for all of those reasons, we feel that there's a number of issues with the language of the bill and the way it's drafted that warrants a larger discussion, which the Office of the Public Defender, specifically myself and some other staff members, would be happy to contribute to. Thank you.
All right, questions from the committee? All right. Well, I got to tell you, it usually takes until about the third week of session before I think to myself, I'm going to go home and hug my daughters a little closer tonight. This definitely invoked those feelings. and only our second day of bill hearings. But just one thing I want to say to the secretary and your team and to everyone else that lent their voices to the debate, thank you all for your work, because this is a significant issue that our state is facing, and one thing is we all want to fix it. So I do appreciate the work that's gone into this, and to the senators, thank you all for your questions. With that, that'll end the hearing for Senate Bill 191. Thank you all very much. We'll now go on to our final bill of the day, Senate Bill 205.
Surprise, it's me. I've learned not to curse the universe and say that anything is easy, but I think this one is slightly different than the other two. Good afternoon, Chair Smith, members of the committee. I'm Rafael Lopez, and I serve as the Secretary of the Department of Human Services, and we respectfully urge your favorable report of SB 205. As with our previous bill, we are driven by our 12 more Miller administration values and believe this bill exemplifies those values. SB 205 prioritizes moving with urgency to ensure all relevant records of abuse, neglect, or exploitation of the adults we serve through our Adult Protective Services, or APS office, can be seamlessly shared with fellow governmental entities conducting investigations. APS serves adults 18 or older who lack the physical or mental capacity to provide for their daily needs. We are charged with preventing or remedying the abuse, neglect, self-neglect, or exploitation of adults who are unable to protect their own interests. Our Adult Protection Program provides professional services to protect the health, safety, and welfare of the adults we serve. SB 205 will increase protections against maltreatment and assist in prosecuting abusers. The bill enables faster and more coordination between federal, state, and local governmental entities during the course of a governmental investigation into adult maltreatment. Coordinating governmental entities include the U.S. Department of Justice, U.S. Postal Inspector, and state agencies like the Office of the Chief Medical Examiner, the Office of Healthcare Quality and Security, and the Securities Commissioner. Under current law, sharing information with other governmental agencies can only occur by obtaining a court order, which creates unnecessary delays in investigation, resolution, and help for victims. SB 205 streamlines record sharing so that investigations can be completed much faster, with greater urgency and justice provided sooner. We appreciate the opportunity to give testimony, urge a favorable report, and welcome your questions.
From the committee. All right, God bless. Thank you very much, Mr. Secretary.
Yes, sir.
With that, that'll end the hearing and the for Senate Bill 205 and our bill hearings for the day. We are going to pause for 5 minutes, and we're going to go get that goldenrod and vote one bill out. So 5-minute break, and then we'll come right back in. All right. Welcome back to the Judicial Proceedings Committee. Today is Tuesday, January 14th, 2025. It's 5:15. We've got one bill on the docket, and that is Senate Bill 54. Before we vote, I want to say just thank you to the committee. I thought that was a really, really good session. Really tough issues, and the questions were amazing. So I just want to say thank you all for digging into the material. Please have that same gusto tomorrow. We have a really important briefing, and so as a reminder, I sent the report that the briefing's based off of, but also some questions that I came up with. But you feel free to supplement or use those as well. But I think tomorrow is a really important briefing for all of us. With that, Josh, go ahead and explain the bill. Let's go get this goldenrod.
Senate Bill 54 makes permanent a temporary requirement for the MVA to make available specially designed vintage reproduction registration plates. The bill establishes an initial $100 fee and a renewal fee of $25.
All right, motion is for favorable. I have a second. Do we need a roll call? All right, Senate Bill 54 passes unanimously. Thank you all. That concludes the end of our voting session. Boom.